Do it on here. Share screen. There we go. Hey guys, we're just getting the movie set up. Okay, window. It's not going to show me. It's not showing me that window. Wonder if it won't let me share that window. Let me see if it'll let us share that window. Ooh, it does. Okay. So you guys, can you see that window? I don't think I can make it any bigger. Oh, wait, I can.
So in your presentation.
Oh, then we can't see us.
Put us in a window.
We're in that. It might be tiny for you guys.
Well, seeing it's not important. Hearing it's important.
Yeah, hearing it's the most important. So, yeah, okay, yeah, so you can see the pimple on my noses. Of course. Lunch. You're such a great moderator, Lunch. I appreciate it. Okay.
I can't see them.
You can't see them?
Nope.
Okay. See, the husband can't see them. Okay. So what we're gonna do here today is we're gonna go over this Supreme Court hearing on the TikTok ban. So it starts at 5 minutes. So let me give you guys an introduction first, okay? I know Launch has watched it. I don't know who else has watched it. But this Supreme Court hearing on the ban is going to determine whether or not TikTok can continue operating the way it has been in the United States, right? And it also has deeper implications. So if the Supreme Court decides that TikTok is correct and they side with them, they're limiting government, and they're going to say that or the possible outcomes would be that they would say that government overreached or government violated First Amendment, right? Or government violated association rights, which is also First Amendment, okay? If they decide for TikTok, which is huge for government, because then they're going to be mad because they want to overreach and they want to be able to do these things without any more effort, okay? Or they could remand it back to the lower courts and have the lower courts resolve some further issues. As you'll hear when we listen, there is a justice that is going to say that not even the facts are agreed upon in this case, which is very unusual, okay? Or they could side with the government, which means the government could do this to other foreign entities that own companies. And it could have other implications for other social media apps as well. So there's a lot of possible outcomes to this. We will go over those again at the end. So let me go ahead and fast forward this so that we can get started. Now, Ron has not listened to this whole thing, and I wanted you guys to be able to see his first reaction on some of the content.
I haven't even studied the briefs or the previous cases, and I couldn't tell you other than what she just said, what the exact complaint is about, or the appeal is about. I know about it in general, and I know the concepts very well, so I'll be responding to the concepts.
Okay, so it starts about here. All right.
Volume up.
Yeah. Well, okay, so I'm going to, hopefully this volume will be high enough. You guys let me know if you can hear it, okay?
Mr. Francisco.
Oh, I need to make sure that volume is shared. Hold on, you guys. I got to make sure that I shared the volume at the same time that I shared the screen. I think it is. Okay, I think it's shared.
Asking if they can hear it.
Yeah. You guys tell me, can you hear it? Oh man, it went back. It went back. No. Okay. All right, there we go, guys.
We'll hear an argument this morning in case 24-656, TikTok versus Garland, and the consolidated case.
I don't think you can hear it.
Mr.
Barely.
Chief Justice, and may it please the court. Under the
I can read
Act,
it.
one of America's most popular speech platforms will shut down in 9 days. That shouldn't happen for 3 reasons. First, TikTok Incorporated is a U.S. company speaking in the United States. The Act requires it to go dark
Computer
unless
speaker up.
ByteDance executes a
Does it match?
qualified divestiture. Whether you call that a ban or a divestiture, one thing is clear.
And the
It's a
YouTube
burden on TikTok
volume.
speech. So the First Amendment applies.
up over there.
Second, the
Turn
Act
that
is
up.
content-based from beginning to end.
Yeah.
It applies only to social media platforms that have user-generated content, except for business, product, and travel reviews. Within that content-based universe, it singles out a single speaker for uniquely harsh treatment. And it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda.
Can you pause it here?
Finally, the Act can't satisfy any standard of scrutiny.
So I just want to throw something out there. So just recently, there was a Supreme Court case having to do with, I believe it was Facebook, one of the same kind of content publishers. And the Supreme Court, that opinion came down where the Supreme Court addressed, I think it was Facebook, as a publisher, and not in terms of the free speech rights of its members, but of the editorial rights of Facebook. And that's an important distinction in that first statement of his.
I think I'm going to play it from here because it'll be louder.
I can hear it just fine.
You can?
Yeah.
I don't think they can hear it. Okay, Wolf can hear it. Okay. Thank you, Wolf.
The government has no valid interest in preventing foreign propaganda. And its fallback, that it seeks merely to prevent covertness, makes no sense, since that could be addressed with a risk disclosure. The government's real target, rather, is the speech itself. It's fear that Americans, even if fully informed, could be persuaded by Chinese misinformation. That, however, is a decision that the First Amendment leaves to the people. Given that the government's data security rationale cannot independently sustain the Act, it is also...
So the way it falls to the people is the people have a right to receive information from other people here. They have a right to speak, but that right can be limited to certain degrees as long as there are other alternative ways of speaking, depending on the level of scrutiny applied. But the Chinese company that owns TikTok has zero First Amendment rights, none whatsoever. And generally, the way the rights of corporations are determined, and most people think we consider corporations persons, but we don't really technically. The way we consider associations, and this was well discussed in Hobby Lobby, is that corporations are associations of people for a specifically defined purpose, and the rights of the corporation are derived from the rights of its owners, who are the shareholders. And those rights may be different based on the nature of the shareholders. For instance, Hobby Lobby, all the shareholders were close family members. They all agreed on the same religious-based purpose for establishing and operating Hobby Lobby. And so when the corporation Hobby Lobby spoke, its speech was very closely tied to this very small group of people who all agreed on the message that Hobby Lobby would be sending. This is very different from a massive public company like Facebook, who has millions of owners who don't agree on anything.
Also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the president-elect, potentially moot the case. I welcome your questions.
Exactly what is TikTok's speech here?
TikTok, Your Honor, uses an algorithm that in its view reflects the best mix of content.
Okay, you guys, you understand who gave the opening statement is the TikTok lawyer, okay? And I believe the one who just asked the question is the Chief Justice, Justice Thomas.
No, Roberts.
Oh, it's Roberts, sorry.
Chief Justice is Roberts.
Roberts. So they don't always announce who's speaking, but you'll probably get used to their voices, and every once in a while they do say who it is. But if you have questions, just type in there and we'll try to answer it.
What the act does is it says TikTok cannot do that unless ByteDance executes a qualified divestiture. That's a direct burden on TikTok speech, much less of a burden than the one that this court struck down in the Simon and Schuster case, where all the author had to do was take a certain amount of proceeds and put it into an escrow account for a short period of time to satisfy a civil judge.
So why?
All right, so this is important. Let's pause here. So this attorney is asserting TikTok's right to speak, but TikTok in this context is its owner, and that owner is a foreign corporation, a Chinese foreign corporation. That Chinese foreign corporation has no First Amendment right to speak whatsoever. So this line of argument fails for this attorney because it's unsupported. There's no right. TikTok has zero right to speak. Now, Americans may have a right to hear things on the platform, particularly from other people, and the government may not have any interest in depriving people of the right to hear foreign propaganda. But that is not the same thing as saying that foreign government has a First Amendment right of their own that can be protected under our Constitution. That just doesn't exist.
Which is not a citizen, is not located in the U.S., a restriction on TikTok.
Because what the law says to TikTok is that TikTok, you cannot use the algorithm that you prefer to use unless ByteDance executes a qualified divestiture. So the law therefore falls directly on TikTok itself. It imposes a burden on TikTok speech, again, a much more significant burden than the one that was struck down in Simon and Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok's as a restriction on ByteDance.
Because I think the burden falls directly on TikTok, and I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos's international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos's First Amendment rights. That would also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law, because they have to go dark and close up their books.
Counsel, you began by saying this is a U.S. company operating in the United States.
Yes, Your Honor.
But the ultimate company that controls it, ByteDance, was found by Congress, and it's, quote, this to be subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work and to ensure that the Chinese government has the power to access and control private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor,
Will you tell me to pause it?
No.
Oh, okay.
I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and
Well, just to hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States. And it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok and its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters because...
So I've said this already, but I want to reiterate that ByteDance does not have its own free speech rights. That is a misrepresentation of the source of rights. Corporations aren't individuals. The Constitution protects the rights of individuals. The corporations are only individuals in the legal fictional sense, in that they are state defined, state created associations between people for certain purposes that get a certain legal treatment, and among that legal treatment is for those corporations to be able to sue and be sued as a corporate entity. But ultimately, that suing and being sued is reflective of the rights of the owners. Now, of course, one of those rights of the owners in a corporate structure is that the owners have no liability for those suits other than the loss of the value of their investment. So their stock value may drop to zero, but that's the limit of their exposure in that company. Whereas if they were in a private company, a personally owned company or a partnership, then their liability would not just be the company's liability, but it would also extend to their person, so that if the company were sued, then they could be subject personally to have to pay that judgment. That's one of the important reasons why people tell you to form an LLC, which is a type of corporation, or an S corp, which is a more specifically a form of incorporation. And because those have elements of protecting you from damages for suits against the company, it insulates you from the company, right? But then that insulation creates some elements of that company is an entity in and of itself. But you can't create too much distance between the owner and the existence of the legal fictional corporation, or it all breaks down. And they discuss that in Hobby Lobby.
Even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion, so that the people who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel, let me break this down. I understand your argument that
Just
there is a
Sotomayor?
First Amendment right that the U.S.
Yes.
company has. I'll go that far with you, okay?
I'll take it.
Because we're affecting their ability to talk in whatever way they choose. The Washington Post could choose without any influence or threat against the children of Mr. Bezos to promote Chinese policy, and our First Amendment would permit them to do that if they chose it independently, correct?
Yes.
Now the question becomes, so it's not, that's just a given that they have a First Amendment right. The next question is, assuming they do, what's the level of scrutiny we apply? Isn't that what the issue here?
That is certainly one of the issues, Your Honor.
All right. So if we get to
She
that
goes
side
far,
of
far
the
beyond
issue,
what the
that
case law
TikTok
will
USA
support. And of course, that's her privilege as a Supreme Court justice. But she doesn't rule alone. There are 9 of them, right? And it takes a majority to prevail. And the current established rule is not that those corporations have an independent right, because a corporation just doesn't exist in any real tangible sense. It's a legal fiction. It's not a person. You can't put the corporation in jail, right? You can't kill the corporation. You can shut down a legal entity. You can stop it from doing business, but it's not a living, breathing thing that can be killed. And so the analogies just break down if you push too far. and she's not being critical enough in this area, possibly because she has a political interest one way or another. Perhaps she has a judicial interest pushing it one way or another, but her accepting it doesn't make it controlling. It takes a majority to do that.
Has some sort of First Amendment right. Taking your example, if the government said no speaker is free to speak under a criminal compulsion by someone else because of extortion, because of kidnapping, we are doing this because it is the only way to ensure the safety of people, that they are not going to be kidnapped or threatened, their lives threatened. You don't think that the government has a compelling state interest in saying, if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that. You can't speak.
Sure, Your Honor. So to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example, generally applicable laws like the
So
trade.
you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to.
So
That,
Sure.
that's the only.
So an important point about a compelling state interest, or any state interest for that matter, that the state always has an interest in the health, safety, and welfare of the people in the country. That's a given. It always has that. That's not the question of whether it has a compelling interest in the health, safety, and welfare of people. Because if that were the case, and if that was all it took, then we wouldn't need the courts, because the government could do anything it wanted anytime it wanted to under health, safety, and welfare. This is very common in family law, where they use this broad, overreaching concept of health, safety, and welfare to say we can declare, based on our sole judge's opinion of what's best for a child, we can violate any rights of the family we want. Well, this is the same thing here, and the level of her analysis. Now, some of that may be, she may be doing this intentionally to facilitate, a broad communication and people to understand without knowing all these details, or she may be intentionally trying to steer away from or change these details. But if the government is going to restrict speech, it has to have a government purpose that is not only legitimate, but it is tightly connected to the laws, and the laws are shown to be very limited in how much of the right they infringe upon to meet the legitimate interest, right? Or the compelling interest. And what that means is that they can't just throw in, we'll violate this right and that right, even though it doesn't relate to the goal that the government's trying to achieve. Right? And so that goal has to be very narrowly stated in terms of the person or entity that is subject to the suit under the facts and conditions of the suit. That's the only way to establish compelling justification, because that's the only way the person being sued can defend themselves. It's impossible for you to defend yourself against a government agency that says, I'm here to protect your health, safety, and welfare, and I'm going to take your house. How do you defend? You don't. So the government has to say, I have a specific compelling interest in taking your particular house from you as an individual, and this is what it is. And then you have something to defend against. And so her statement is taking all of that detail away for whatever reason.
Remedy the government could undertake?
No, Your Honor, but I want to make sure I understand the hypothetical. The compelling interest is in preventing this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways they can address that through speech neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say and attack
They haven't
problems.
been very effective.
Well, be that as
we're still having people kidnapped. We're still having coercion.
and be that as it may, you can say to Americans,
that were the
you cannot
standard-
collaborate with our enemies at all.
If that were the standard, and I agree that it is the standard, because that if it's not effective, then it's not, then the means applied are not rationally related to the objective. Because to be rationally related to the objective, they have to have some level of success against the objective. That's the law, right? And so it's easy to argue that the drug war, for instance, is a complete and utter failure. And rather than reduce crime and reduce drug use, it's had the completely opposite effect. And if you demonstrate that, then it's also true that that effect is not even rationally related to the goal of reducing crime, reducing illegal drug use. And the same here, and the same in family law. The government has no legitimate interest in depriving children of fit parents. The Supreme Court has said this on multiple occasions. And yet that's exactly what they do in family law, even though they have no legitimate interest. So what is and how they manipulate it in certain contexts is interesting to get into if you're a legal geek like I am.
And if you do that, you're going to be severely punished for doing
All
that.
right, we can
But what
go
I
on
don't-
to the effectiveness of the remedy, but the point is, I believe that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny,
Yes, Your
and
Honor.
whether that the action is content neutral or not.
I agree that that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the DC Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises in the context of bandwidth scarcity. And in that context, you have the government that's in the position of doling out a limited number of licenses. And when you have to dole out a limited number of licenses, you by definition have to pick winners and losers. And when you have to do that, you get a certain amount of discretion. I think that's the whole basis of those cases. You can't really take those cases
Keep going.
You can't really take those cases and extend them to an area where there is no scarcity like the World Wide Web. Because once you do that, there's really no limiting principle. There's no reason why it wouldn't also apply to really popular books or magazines or newspapers or chains of newspapers. The bandwidth scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
The limiting
Mr.
principle
Francis.
here is what they're whitewashing over is the nature of corporate ownership and the nature of the rights of corporations, and where do those rights come from, and how does that affect what protections are afforded those individuals. And this is not something I'm making up. The Supreme Court has addressed this in a multitude of cases, most recently and most thoroughly in Hobby Lobby, again, which was in large part a First Amendment case.
Let me see if I can break this down. Suppose that TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not?
Because there you would have to confront a very different question, whether a foreign government that was speaking in the United States has First Amendment rights. And I don't know that the court has ever addressed that. But here we've got a U.S.
No, I
government.
understand that. I just want to see where you draw the line. So it's true. The court has never held that a foreign government has free speech rights. And if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not protected. Allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume that we start with that. All
We
right.
shouldn't assume that.
What if TikTok?
The reason we shouldn't assume that is because the Chinese government is a sovereign government. It is
Sovereign.
a sovereign
It's
government,
a sovereign government.
right? Which means it's not subject to the laws of the American laws, the American courts. It cannot be restricted in the American courts. And therefore, one reason among many, the Constitution simply does not apply to the Chinese government, nor to any foreign individual who's outside of the direct control of the federal government and the scope of the Constitution, right? The Constitution is geographically limited in large part to the scope of legal authority that the government has. The First Amendment has no application in Cuba, in England, in Germany, or anywhere else. And they greatly restrict speech in those places.
So Launch has some questions that he posed in here, and he thinks they should be answered when they pose them because they're asking them related to what's being discussed. So he said,
I can't read that very well.
Hold on, we're looking at the questions real quick because Launch brought something up and said, I said that questions would be answered towards the end, but then he was saying if the questions are related to what we stop the video to talk about or what the video's on, then we might stop it and
I agree.
to it.
That makes more. It'll make more sense to you if we discuss it while it's fresh. Otherwise, you'll lose the connection, in my opinion.
What stunt did you pull, Launch? Launch said he had over 800,000 followers on YouTube until he pulled a stupid stunt and it got him banned off YouTube for a long time. What did you do? I want to make sure I don't do it. Okay. Facebook don't like. Okay, so Wolfie's responding to that. And I'm just making sure. Okay, that was before the video started. Aren't we already protected from the company? What did you mean by that, Launch? Aren't we already protected from the company? That was that.
All right. So the Constitution does not protect you against other private individuals in general. There's one exception that I know of to that, which is the 13th Amendment, which says the conditions of slavery or involuntary servitude shall not exist in this country. And that applies to individuals. But it's the only constitutional limitation that I can think of off the top of my head that does. Everything through the 14th Amendment only protects against state action with one very narrow set of circumstances, which is called the state action doctrine, which is the subject of one of our books, Oathbreakers. And a person can get themselves classified as subject to that state action limitation
Didn't mean to do that.
if they do certain things that closely align their actions with the government and basically conspire with the government to injure someone. If they can't do it except for having the government's power to do it, and that's improper for the government to do it, then they can potentially be sued.
Okay, so Launch also said the government let Trump go free over his 34 felonies. So why do they not just dismiss this whole thing over TikTok? Because the people have spoken numerous times. And if TikTok is not allowed to stay, there is going to be a nationwide riot that is going to be out of control. And a lot of people are going to end up getting hurt over it. And that's something that should be prevented and that the government should want to prevent.
Well, actually, they have a significant case law on that, and the potential for unrest is not a justification that carries much weight with the court, because that would allow the government to do pretty much anything it wants. There's recent cases, they're not recent as far as being heard, but there are cases we use in family law, and I can't think of the names of them right off the top of my head, that say that exactly. They're free speech cases. And actually, I do. I was still recall the name off the top of my head, but they have to do with the purpose of the First Amendment, which is to preserve your ability to disagree and to express disagreement, right? So the First Amendment doesn't matter if everyone agrees that the speech is okay, then the First Amendment's meaningless because there's no conflict. It's when people disagree, when there's a conflict and they say, I want to speak and you won't let me, that's when the First Amendment becomes important. And this is important in family law because some states like Kansas, their state Supreme Court outright says that the reason the state invades the child's family life is because the parents got divorced, and that divorce stokes discord or disagreement between the parents, which creates the potential, the possibility of speculative nature of an injury to the child. Then that injury, they define it as a parent making a selfish choice or selfish child rearing choice. Never mind that selfish child rearing choice is constitutionally protected, and the Supreme Court has directly said so. The point being is that Kansas is punishing the disagreement between the parents and saying, because the parents disagree on what's best, an arbitrary concept, if ever there was one, what's the best football team? Anybody want to give me an absolute definitive answer on that? You get that's not possible, and we'll be fighting all day, right? My best buddy, right? Which that's pretty much absolutely protected, and yet family law, they use it because they try to ignore the Constitution. So far, they've been able to get away with it. But it's the same here. It's the disagreement that matters. The disagreement is protected.
Okay, so Faith said true, but the people that own the company want it to be a trusted app across all countries and is a business. We know what information they have on each of us, and we know how algorithms work. Should be our choice.
People who own the company, for the large part, are not Americans. They are foreign nationals, and that goes directly to the degree of rights that the corporation has.
And I think you're going to hear later in this case, Faith, they do talk about the way that this algorithm works is it's also giving them information on people that you're connected with. Like when you authorize it to connect with all of your contacts, it's giving them information on people who aren't even giving their authorization to have their information shared with this application.
And in terms of less restrictive means, you may or may not know this, but Europe has a data protection law, the European Union. And what it requires is that if you collect private data about any European citizen, when you're operating in those countries, all of that data has to remain within that country. So when you look at something like cloud computing, and I've got 25 plus years of IT technology and business management experience. When you look at something like cloud computing, it's important where you pick your segment of the cloud to be, and you generally can pick multiples for redundancy. If you're storing European data, those segments have to be in Europe. They can't be anywhere else. Otherwise, you're in violation of European law. They will come after you.
They have laws here as well that people have a right to know where their data is going, to ask the data to be scrubbed from a database and things like that.
Incredibly limited compared to the European data protection laws, because it causes constitutional conflicts that they just don't have in those countries.
Okay.
Government, but it was undisputed that TikTok was totally controlled by the foreign government, could not do one thing without the approval of the foreign government. That's different.
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given, but there are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German owned, or Al Jazeera, which is partly owned by the government.
Well, I understand that, but what would be the reason for drawing that line?
Sure,
because there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States. Why would it all change if it was simply hidden under some kind of contrived corporate structure?
Because it is a U.S. speaker I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like or promote any movies that Congress wanted. And I think the reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself.
All right, let's say that's not a
United States company.
Let's say this is not a complete answer to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation?
Well, Your Honor, I think that it does help supply a compelling governmental interest.
It is an important fact, and it should be, in that the foreign speaker has no First Amendment rights, but the American listener does. And those rights are sufficient in a case such as that to make it incredibly difficult, if not impossible, for the government to impose any meaningful restrictions. This case is considerably different, for one reason, because it really is about espionage more than speech, which increases the government's interest in it.
But I still think you have to march through the strict scrutiny analysis and analyze their interests. I do not think that they have a compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment. And if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy. Yes, Your Honor.
Mr. Francisco, I just wanted to follow up on that line of questioning with just some fact questions, because it seems to me there are a couple of things that the parties still dispute about facts in this court, which is a little unusual. The government says that TikTok US has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
somebody
we do.
has to be right and somebody has to be wrong about that. What's the fact? What does the record show?
Well, Your Honor, we are here on a record, and there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
All right, what is the fact? Are you prepared to make a representation?
Yes, Your Honor. The fact is that TikTok Incorporated, as a U.S. company, does have a choice over the algorithm. Now, it would be an incredibly bad business decision for them to abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated, as a U.S. company, does have its own set of First Amendment rights.
Okay, and then another fact question. Before the DC Circuit, you argued that the Chinese government has made clear in public statements that it would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact that this is being operated in the United States by TikTok Incorporated.
Okay.
So
I got it.
Okay.
I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions.
Sure.
I just want to understand what's before us. Would it be feasible in any time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be
Your Honor, I think, at least as we understand how they've interpreted the qualified divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons. The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States, that maintain and update the original source code. And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason is because, as we understand how they're interpreting it, a qualified divestiture would divorce the U.S. platform from the global content. So, for example, there are videos created in the United States.
So there are ways, technically and organizationally, to segment developers who write code and engineers who deal with integration of that code from data, right? So when you have personal data on individuals that's sensitive, you don't give every one of your programmers in your company access to that data. In fact, corporations spend a staggering amount of money simply creating fake data that's representative of the data that they have in their real databases. And the programmers use the fake data to do all the testing, all the building, all the designing. If there's testing against the live data, it's done by a very restricted group of engineers, and not, you know, the wide group of engineers all over the country. I have personal experience with this kind of thing.
Videos created in Ireland. In order to get global content, we need access to the Irish videos. They need access to the US videos. We understand that couldn't happen.
Okay, so you think it's probably not feasible in any timeline?
Well, Your Honor, I think it'd be extraordinarily difficult.
Okay, last fact question.
And just real quick,
here. The government
my point in that statement is not access to the published data. What you say publicly on TikTok is not the data that I'm talking about. What I'm talking about is the data that they collect about you, and that's what the law is targeting. Is, in large part at least, is the basic data they're collecting about people, and how that data can be used to tie to everything else in our connected world. That just a few pieces of information about you can get thousands and thousands of other pieces of information about you, and can be used for nefarious purposes. I mean, they could go in and start on a whole scale basis, start doing identity fraud against people from their database, and they would have the means to do that easily. Now, they wouldn't do that in the normal course of business, but if the current conflicts between China and the U.S. got even more heated and more confrontational, and we started moving closer to a war footing, or if China invaded Taiwan, for instance, which they threaten to do on a daily basis, then everything changes, right? And then all of that data that the Chinese government has access to, personal private data of Americans, becomes real detrimental, which is seriously different from the issues in the 30s with the Soviet Union and Soviet propaganda. The magnitude of the impact and the ability to do real warfare harm to the United States is significantly different in the context.
There's no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. And you deny that in your reply brief. Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things. The record shows, first, what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency.
Removed or restricted, though, doesn't necessarily.
However, as proven and documented and admitted to by the actual players, the United States government has in fact done exactly that with Facebook and was it now X now, that used to be Twitter. And so that's very real. When our own government does it, we have to consider that the Chinese government is going to do that and far worse, right? And in my opinion, the court in that case improperly ignored all of its reasoning in Hobby Lobby in those cases and came to the wrong conclusion in treating Facebook entirely as an in the same vein as a newspaper who pays reporters to go out and report on the news for them, in which case the content is directly created and owned by the corporation, and then the corporation rightfully has editorial control over its own speech. And that's very different from providing a platform whereby I get to speak to you without expecting any kind of control by the platform. I get that they do it. I don't like it. I don't expect it. I would like it to stop. I want them to act like my phone company. Phone company doesn't listen in on my calls and say, you can't say that, because federal law prevents them from doing it, because they are just a platform and they have no editorial authority over what other people say. Now, they can still have editorial authority over what they themselves say, but they don't have any editorial authority over your phone calls. And in large part, Facebook and Twitter and these others should be treated exactly the same.
Cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record.
Okay.
It's very difficult for me to respond to things where I don't know what the accusation
I have other
is.
questions about the secret evidence in this case, but we'll get to that later.
Yes, Your
Mr.
Honor.
Francisco, can I ask you a question about the relevant speech here? So it strikes me that this is a little different than your Bezos example, because there it's clearly content discrimination, because we're talking about the ability to post particular articles versus other articles. Am I right that the algorithm is the speech here?
Yes, Your Honor. I would say the algorithm is a lot of things. The algorithm has built within it. It's basically how we predict what our customers want to see.
I would argue that the algorithm is the associational element of speech rather than the direct element of speech, because the algorithm doesn't speak. What the algorithm does is associate you with someone else and shares your speech with them. So the algorithm is facilitating speech, and it's still a platform. It's not TikTok's speech. It's TikTok's dictating who gets to associate with who gets to see that speech. And it's not their speech they're restricting. And you have to remember that corporations are not private individuals. They only exist because law allows them to exist. They barely existed at all when our country was founded. They were an amazingly new concept. The first one was ever actually created by the British government, by the king. And it was created what was that? A trading company. I forget what it's called, but it was a worldwide trading company. That was the first corporation ever to exist. Okay, so corporations aren't natural. When you talk about natural law, when you talk about a free market, corporations don't exist in a free market. Corporations exist in a market that has some form of government involvement, where they can create the entity and the laws around that entity. But that's not a natural part of a free market. And so those concepts really, really are important here. And it doesn't sound like they're getting into any of them.
Editorial discretion.
Yeah, the editorial discretion. It also.
Did you see
No.
Launch's
I can't read
question and
those.
Pam's? Okay, Launch said, well, if they have a business here in the United States, they should be under the same laws as every other business here in the United States.
Oh, stop it. So the business itself is subject to the laws of the state. All right. But the business, again, is a fictional non-entity. It doesn't exist. It's not real. It's a set of government statutes that say we're going to pretend that this is an entity and give it certain statutory existence. But beyond that, it doesn't exist. It's not a part of the natural world. Okay, and so the rules don't apply the same, and the court has been very clear on this, when it's in their interest to be clear on this, that the rights of the corporation to speak are directly tied and derived from the nature of the individuals associated in the ownership of that business.
And so Adventures with Pam says, we need privacy laws in the U.S. We are far behind most of the world.
Yeah, well, the problem with most of the world is their privacy laws are not protecting your freedom. They're imposing dictates on others about what those others can do with information you gave them. Right? That's a very, very different thing. And again, the Constitution generally protects individuals from government, not individuals from individuals. Statutes are intended to protect individuals from other individuals, and those statutes have to follow constitutional rules. They have to exist within the constitutional boundaries. So we can't do the things that they do in Europe. Our Constitution does not permit the level of tyranny they permit in Europe. And I've lived in Europe, and there's a lot of things I love about Europe, but their degree of tyranny and limitation on your privacy is certainly not one of them. And by the way, I've seen the East German wall, if you will, where I saw it, it was just a big fence with watchtowers and all that. But I have personal experience with that old Soviet Union and East German deal where all their people were behind barbed wire and gun towers.
Sad. He was over there he was in the army. Yes. Okay.
Built within it, the moderation elements, all of this kind of comes together when the source code is translated into executable code in the United States. In the United States, that executable code is then subject to vetting, review, moderation through content.
Sorry, guys. Oh, no. Oh, no.
A little further than that.
Boob hit the keyboard.
No boobs.
Pam will understand that.
In this court, which is a little
Is that
unusual.
right? Where were
The
we?
government says that TikTok US has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
Somebody
we do.
has to be right and somebody has to be wrong about that. What's the fact? What does the record show?
Well, Your Honor, we are here on a record, and
No,
there's
we're
nothing in the
way
record
behind.
that says that
All right.
TikTok, like any
So-
other subsidiary.
Let me see if I can push it up forward. All right. But again, the algorithm is not their speech, it's their editorial of your speech. And the real issue is how much editorial power do they have over your speech? You know, in the scenario that the real thing they measure against is phone companies and pure platforms, and they have zero editorial control over it. So they're stretching badly the underlying principles and law here.
And leaves TikTok with the level of interference, indirect.
Does something, and that's imposed by the force of law, and that would get no First Amendment scrutiny by anybody.
Generate strict scrutiny. I'm not sure that we've ever said anything like that.
Where were we?
Be critical of the United States or undermine
Yeah, I think this is where we were, maybe.
one speaker, and then just to make the rubble bounce, they come in and tell us that one of the
Sorry, guys. Boob bump messed up where we were, and I didn't see the time on there. Pam says I meant more the privacy of our data with corporations, that we need more privacy laws with that.
That I would agree with. And if you wanted to get into financial privacy against the government, I would strongly be in favor of that.
Okay, let's find where we are.
reasons they're targeting that speaker is because they're worried about the future content on that platform, that it could in the future somehow be critical of the United States or undermine democracy, to pull examples from the government's brief. So I think there's no way to get around the fact that this is a content-based speech restriction, and you do have to go directly to what their interests are. Now, their principal interest is...
Could I, because I think I'm a little bit surprised by one of the answers that you gave to Justice Barrett. I had understood that TikTok's essential complaint here is that they wouldn't be able to use the algorithm that ByteDance has invented, and that they want to use the algorithm that ByteDance has invented.
100%. And if I was unclear on that, Your Honor, I apologize. That is
okay, because I think
what
what Justice Barrett was saying to you is like, what's the problem here? Because ByteDance is a foreign company. Or maybe this isn't what Justice Barrett says, it's just what I say. ByteDance is a foreign company. And you started off with Justice Alito saying, you know, well, we would be making a different argument. And of course that's true. I mean, I would think that Alliance for Open Society makes it pretty clear that you have to be making a different argument with respect to a foreign state or a foreign company. So let's say that they don't have First Amendment rights. The only First Amendment rights lie in TikTok, which does have First Amendment rights. And
I guess my question is, how are those First Amendment rights really being implicated here? This statute says the foreign company has to divest. Whether or not that's feasible, however long it takes, TikTok still has the ability to use whatever algorithm it wants, doesn't it?
No, Your Honor, and their rights are implicated at a most basic level. In 10 days, TikTok wants to speak. In 10 days, because this law was passed, TikTok cannot speak unless ByteDance executes a qualified divestiture. That's not just ByteDance's choice. That is a condition
Well, I
that's
realize
imposed
that
by law.
it definitely has effects on TikTok if ByteDance acts in the way that you are assuming it will act. So this is not to say that the First Amendment isn't involved, because TikTok is going to suffer some pretty severe incidents. They are incidental, aren't they? Because the statute only says to this foreign company, or else, and leaves TikTok with the ability to do what every other actor in the United States can do, which is go find the best available algorithm.
I very much disagree that the effects are incidental, because the way that this law works is it is only triggered if somebody is engaging in speech based on their content. User-generated content, except for business, product, and travel reviews. It then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
The idea of just like, I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that.
Yeah, and that's not how it works.
Facial.
It's not the fact that the law is content based. It's that the law infringes the individual personal rights of an individual, individually protected personal rights of the individual. That's what the Constitution protects. And it doesn't protect broadly against content based restrictions. It only protects when those restrictions create a real concrete injury to a specific individual that can be traced back to someone doing something wrong.
Isn't Justice Sotomayor, didn't she just say TikTok has First Amendment rights?
Yeah, but
is she just like saying theoretically, like, let's say it's this way?
I'm not sure how. I'm not sure about her. I haven't read enough of her stuff to know whether she has that intellectual depth to be that familiar with all the case laws. You would hope she does, being on the Supreme Court, but that's not a given, because that's a political process. I mean, she's got a lot of depth in a lot of areas, and I'm not trying to criticize her. I'm just looking to see whether she's making an assumption that isn't based on reality, or isn't sufficiently based on sufficient detailed, nuanced understanding of the principles and how those principles interact.
Usually they'll say, well, say they have First Amendment. Like, usually they'll say it like that, and I don't know if she just like slipped, or if she's saying they have First Amendment rights.
Or she's making a political statement and trying to rig the game by saying something so that it will come true. That's a basic psychological trick. If you want to manipulate people, is to talk about the future as if it's already existed, and in their minds, they will automatically snap to believing it already existed unless they're prepared and
the other justices aren't going to
understand. No, the other justices are going to fight back against that, but that's a basic trick. I don't know if she's playing those tricks or if she's not sufficiently nuanced on the topic or what. It's impossible to know.
Okay, thank you.
Like your argument that this is facially content based, it seems to me that your stronger argument, or at least the one that most interested me, was this argument of, look, if the government is doing something specifically for the purpose of changing the content that people see, that has to be subject to strict scrutiny. But I don't see that.
What the heck?
That as affecting TikTok, as opposed to as affecting ByteDance.
Well, I very much do see it as affecting TikTok, because they choose this algorithm because it reflects the mix of content. The government's fear is that China could come in and pressure TikTok through ByteDance to TikTok to alter that mix of content to make it too pro-Chinese or too anti-American. That is very much directly a content-based charge straight at TikTok. The other point I would like
I
to,
hear you that it might very well have that effect. I guess what I'm suggesting is that the law is only targeted at this foreign corporation, which doesn't have First Amendment rights. Whatever effect it has, it has. You know, maybe ByteDance will figure
No,
out a
she
way
said
to
like-
put this on open source,
That's
and then
why
TikTok
I
will be able to
wonder
use
about
the
the
so
other.
Your Honor,
intellectual
if I
depth.
could take that on directly, because I think TikTok has First Amendment rights.
Well, I just want to mention something. I think they're talking about it from two different perspectives. They're talking about TikTok Los Angeles and Culver City, and that maybe who she was saying has First Amendment rights because they are U.S. based. I don't know what you call, but they're U.S. based. But ByteDance is their umbrella company, but their individual office is in Culver City, and then there's ByteDance, which is China based. So I don't know if she's loosely like if she's bouncing back and forth referring to the one in LA has First Amendment rights because she just said the one in China does not. Okay.
Right. So part of your ability to have a corporation's ability to have rights is that being subject to that sovereign's laws. So this just happened to Twitter or X in Brazil, I think, and that Brazil wanted them to censor speech and they didn't want to do it. And so the Supreme Court in Brazil shut down X in Brazil. And what Elon Musk came to realize is no matter how pro free speech he is, that he cannot dictate the sovereign laws in the sovereign country, and his business has to follow those laws, or it will be prevented from doing business in that country. It won't be able to have offices in that country, or computer facilities, or to collect money, a whole bunch of things. So they need to be able to physically do business in that country. That forces them to be subject to the laws, but that doesn't necessarily grant them all the same rights as individuals in that country.
Right. And previously Ryan had said that's just it though, right? It's like an onion of levels of rights, starting at the top with TikTok, then on to every person using. He was responding to the former comment you made.
In some ways, yes. In some ways, no. So again, the Constitution protects the rights of individuals. It individually protects personal rights, your rights, right? It doesn't protect some foreign entities' rights, some foreign individuals' rights. If you're within the scope of the authority of the Constitution, which is you're physically within the bounds of what the federal Constitution has jurisdiction and control over, the federal government has jurisdiction and control over, then you're subject to that Constitution and its protections. Now, to some extent, an American traveling overseas still gets all those protections in relation to the federal government, but not in relation to those other sovereign governments.
Okay. So where we stopped off was TikTok's attorney telling the justices he believes TikTok has First Amendment rights. He's talking about the one in Culver City, California.
And it's very possible that Justice Sotomayor has, certainly she has more knowledge of the details of this particular case because she has clerks that brief her on everything and analyze the heck out of this. And so they come prepared. So
To the extent ByteDance is speaking in the United States, it, I believe, has First Amendment rights. If you conclude that neither has First Amendment rights, then surely the creators have First Amendment rights. But if you take a step back, what their position is that none of these entities, this is the universe of entities affected by this law, none of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat, or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody. That cannot possibly be the case.
yes, it most certainly can be the case,
position.
and that is exactly the analysis that the court should be doing. Right? It should go down to first principles and say, what does the Constitution protect?
See, and Ryan, he peeled the onion like what you were saying, Ryan. He went from upper level corporation down to the individual users.
So in all of my professional training and experience in quality control and operational excellence and all these things, we always go straight to the root of the problem. I have a background in economics. It's the same thing. The first thing they teach you in economics is always question your assumptions, because if your answer is wrong, 90% of the time your assumptions were wrong.
Well, part of the problem they're having trouble getting to the root is they haven't even agreed on all of the facts of the case.
Yeah, and then that, in my mind, I would kick this back, and I would direct the lower
Told
courts
you, that's
to,
what I was saying.
yeah, I would direct the lower courts to flesh out the specific ownership chains and the degree of First Amendment protection the corporate entity has relative to its ownership.
Which means if they kick it back, they're going to probably put an administrative stay on it.
Yeah, and then let it continue up, because they would have if they kick it back, there's a presumption that violation of First Amendment is unconstitutional. And as long as there's a First Amendment open question about whether or not that First Amendment is being violated, they would most likely keep it open, and most likely not let the government statute stand in that period of time.
And part of that is, I find it interesting that if all of this is a huge security risk and they can't delay it for the Supreme Court to go through their whole process, how is it that they gave them 200 and something days to initiate a sale and then put into the bill the president can extend it another 90, right? So I think the Supreme Court would look at that, because if it was harming the country, of course, nobody's going to want to put an extension on it. But if it's so harmful to the country, because they're doing prospective, they're doing speculative. They're saying it might do this, it could do that, right? Cases that generally courts don't like to see.
But here's the thing with that. If this were Germany, the odds of us going to war to Germany in the next 20 years are practically zero. The odds of us going to war with China in the next 20 years are significantly above zero, and probably come close to 50 for 50, because the guy that's in charge now is just like Putin, and he wants to go back to Imperial China. And that's a problem, because the only way they get back to Imperial China is by dominating their neighbors and reclaiming territory they think is theirs, which is Taiwan. And if that happens, we will protect Taiwan one way or another. Trump might try not to, but enough senators and congressmen will stand up and scream bloody murder about protecting Taiwan that we will end up protecting Taiwan. So we could very well be at war with China in the next 20 years.
Point I'd like to emphasize, though, is this law, like the Playboy case, like the Hobby Lobby case, has built within it a less restrictive alternative, which is the general provision, by definition designed to protect against the very harm the government is identifying. Suppose New York State passes an asbestos abatement
and so
law.
the Playboy case they'd refer to is a core First Amendment case that we use in our briefs and how we help parents fight in child custody, because it defines critical elements of the First Amendment.
These types of buildings have to abate asbestos. In addition, New York Times, you have to abate asbestos in your building, and they say there are two reasons for this. One, we want to abate asbestos. Two, we hate the New York Times editorial page. Surely, at the very least, what you're going to say is you can't target the New York Times directly. What you can do is throw them into the general process.
Thank you,
we think that's the minimum that should be done here.
Thank you, Counsel.
All right, but you can't. That's an unequal protection argument, or equal protection argument, unequally applying the law. But again, a foreign entity, a foreign-owned company, has no equal protection rights in America, so we can target them. And then the president most certainly has that enumerated authority within the Constitution under Article 2?
Between the regulation of TikTok and the burden on expressive conduct. And your basic position is that interfering with the ownership of TikTok constitutes a direct regulation of the expressive conduct of other people. What is your best example in our precedent of a situation where a regulation of corporate structure or something else has been treated as a direct regulation of expressive conduct?
The regulation of a corporate structure as Your Honor, I don't have a case in my fingertips. I can consult.
Well, I don't have one at my fingertips or any other
rebuttal, but I think it's quite clear, though, that if you're saying to a company, you have to stop talking unless somebody else does something, and that's imposed by the force of law, it directly affects that company's speech.
Well, it's again, I don't know if it's directly affecting the company's speech or the speech of third parties, and I'm not sure what, where your emphasis is.
So here's why that matters. So if they have a safety code issue where they're doing the asbestos thing, that's fine in general. But if it involves, even indirectly implicates speech questions, then it requires some form of enhanced scrutiny, not necessarily strict scrutiny, which is the toughest bar for the government to overcome, but it could be a less restrictive kind of scrutiny. It's called intermediate scrutiny, and there are multiple combinations of things they put together in different contexts to get there. But it would still be, there would still be protections. They would just be less than strict scrutiny. And intermediate scrutiny is a very strong protection across the board. It requires the government to prove versus you to prove. So the government has to prove it has authority versus you having to prove that they're acting without authority.
But again, I'm not sure there's another case where we've said that regulating a company should be, others' expression should be treated as direct imposition on their speech in terms of the standard of review, for example, when it's based on derivative regulation of corporate structure of somebody else.
Well, Your Honor, I think that it's, I would concede that this is a pretty unprecedented case. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record, because the speaker that is ultimately being shut down, they don't like the speech of that particular platform. That's a real problem.
So it may be a real problem or may not, but I just am wondering if there's any precedent where we have that same connection and that it affects the standard of review, for example. You would treat it.
Hold on real quick, because I wanted to get a couple of these. Launch says, my personal opinion is all of this nonsense could be avoided and all of the attention could be redirected to where we need it the most instead of directing towards an app. We should be focused on the United States and the state we are in because we are behind every other country in technology and in everything else. And Ryan says, does it make a difference at all that Butane isn't the sole owner of TikTok, though? They own a percentage, ByteDance, but not its entirety.
Exactly. So those are the factual questions that need to be addressed. They need to kick it back to the lower court and let the lower courts address those details and come up with a degree of First Amendment protection along the same kind of logic that was applied in Hobby Lobby to determine what degree of scrutiny applies and who the speaker is and what particular rights they have. Right. So again, the corporation's rights are derivative of the rights of the owners. If all those owners are American, then they have strong First Amendment protections. If the owners are a very small group of people who all have agreed to agree in delivering the corporate message, then they have protections that are almost as strong as individual protections. So those nuances have to be worked out. And the Supreme Court is generally not the place to work those out. It's generally in a lower court, a fact-finding court, usually.
So Pam asked, so who are the owners and where are they located? So Pam, it doesn't really matter who the owners are because ByteDance is actually physically located in China. Hold on. They're located in China and therefore they are under China's control. But I can tell you, because I Googled it, it says as long as, assuming Google's correct, ByteDance's owners include investors outside of China, 60%. Its founders and Chinese investors, 20%, and employees, 20%.
Okay, what matters is its legal existence. Remember, it's not a natural entity. It's created by statutes. If it's created by Chinese statutes, doesn't matter who owns it, it has no rights here.
Right. Right. And then Organic Silver Moon Designs, LLG, she says she's missing some information because she came in later. But her question is, how much black and white facts do we have in writing for which way this headed to on court case with TikTok to hear concrete facts. So Ron did not get to review any briefs or anything, so he's not going to know.
Right. But
that
what I
answer.
can tell you from what I've heard so far is that I agree that they're insufficient facts because in my opinion, First Amendment rights and based on what the Supreme Court said in other cases, the corporation's rights depends on the ownership. And therefore that question is crucial to resolve before we can answer the ultimate First Amendment questions. And the Supreme Court's not the place to get into those details until after they've been established. And then the Supreme Court can review those details, but they don't create the details. They don't establish the record.
Right.
As a direct restriction on expression. Even the only thing the law does is say, in this case, somebody other than the Chinese government has to own.
So we don't have any direct precedent along the lines that you're citing, but we do have precedents. We have cases like Akara. And what Akara says is if the law is totally speech neutral, then that's one thing. We have cases like O'Brien, which say if the law doesn't care about speech but happens to draw in speech, that's another thing. Both of those cases make clear, however, is that when the law is concerned with the content of the speech, when the justification is based on the content of the speech, that's cases like Reed 2, then you do trigger strict
So
scrutiny.
then I think your argument comes down to, is this direct concern with speech, or is it concerned with the potential for Chinese interference with the level of interference indirectly? In other words, they're not coming back. The Chinese government, TikTok, doesn't care what the people are saying, but that's not the concern. The concern is that they are regulating a particular channel of communication. And I just wonder if there's any precedent for that type of thing. They're not saying we're going to restrict this content and that content, but not this. They're just.
So I think where he's leading on this is something the courts do, the Supreme Court does, that I vehemently disagree with, is when the Constitution says the Congress has no authority to restrict speech, then the Supreme Court comes along and says, well, obscene speech isn't included in that. Well, I mean, I could read, and I've read the First Amendment dozens and dozens of times, and it says what it says, and it doesn't say the Supreme Court can pick and choose what speech is protected and which is not. So I vehemently disagree with the courts exercising that power. I think that's an illegitimate exercise of their power. I think all of the questions they resolve that way can be more properly resolved in terms of balancing, in that the speech impacts some other rights, the rights of other people negatively. And so they have that right. You have the speech right. They're in conflict. So we have to balance the rights. The government's not saying, well, your right doesn't exist because obscene speech is content of speech we don't like, which is exactly what they said. Right? So that, I think, is bad law. But if they said your rights conflict with their rights, and so we have to work out how to balance those rights so everybody gets the most protection for the rights with the least harm to the other person's rights, then we come down and make a choice, because ultimately courts are about making choices. But arbitrary choices and just saying, well, the Congress can make laws violating those, limiting that speech, even though the Constitution says shall make no laws. That's just nonsensical. So I think that may be where they're going with it. That justice is going with that argument into a position where the court will say, well, that speech is not protected because whatever it is. Now, that would be a true statement in terms of a sovereign entity owning it, but it wouldn't be a true statement in normal context.
Orion's saying, in your honest opinion, do you think they will issue a stay? The economic issue losing TikTok would have on many levels would be massive. Doesn't it make more sense to extend this and give more time?
Okay, so courts are limited, very limited in their authority, and they don't get to make policy choices. So a lot of your question is a policy-based issue, right? Which the courts don't really have the authority to make. Now, they do take those things into consideration, especially the Supreme Court, because they have no bosses. And they will do it. And they occasionally do make policy, and usually it's very bad policy. It's hard to get rid of. but they will take that into consideration. The Supreme Court is very good in almost all cases in staying within the bounds of their legitimate authority, and they will do things that are within the legitimate judicial authority to do. And that's why they discuss the administrative stay. I think it's later in here where they discuss that. But that is a potential option for them if the court decides that they have that authority.
And you notice that justices are asking these attorneys that are providing oral arguments, even if the justice feels they have the authority to do something, they still want to hear the argument of each of the justices because they want to make sure that they're ruling on all the facts that are on the case. And so you will hear them ask the lawyers, do you feel that we have the authority to issue an administrative stay? And they know, like, they pretty much know the answer, but they look for these things to see, one, they're always watching out for the credibility of each attorney, but two, they're also wanting all the information they can get out of these oral arguments to make the best decision.
So this introduces one of the cognitive biases we all suffer from that we have to balance if we want, or be aware of and protect against if we want to get to something relating to real truth. All right. And so we have to ask, what is the nature of our government? How does it exist? What authority does it have? Where does that authority come from? How was it created? Well, remember, we were subjects of the King of England. We were a colony of England, which means the King of England had almost dictatorial powers over over regulating us. Now, their parliament had some authority and could limit the king in some ways, but the king had extraordinary dictatorial powers over the colonies at the time. And we rebelled against that. And we went to war against that king, and we defeated that king. And so for 10 years, we established a type of federal government, very limited type of federal government under what are called the Articles of Confederation, where the states were the sovereigns, complete sovereigns, and the states came together under a loose set of rules, something like the UN, and said, we're going to have, this very limited federal government because we don't trust government. We just went to war against government, a 4-year brutal war against government. We don't trust government, right? And then that didn't work well enough to protect our interest against foreign governments, to keep the states from squabbling, to make sure that we could have free trade between the states and free travel between the states and all those things. So what wound up happening is 10 years after the revolution, essentially, they had a meeting to fix that. And instead of fixing it, they threw it out and replaced it with a constitution and asked the people to vote for it. And the people the states did not vote for this constitution. The people voted for this constitution. They had an intermediary. They kind of like our electoral college. They voted for a group of representatives. That group of representatives directly voted. So the important part is that state governments were cut out of this, and this went directly to the people. And so the people decided, and that's how come the federal government can overrule the states and where the Constitution gives them authority, is because their authority comes directly from the people, not from the states. Right? So the default in America is not, does the government permit it, or should the government this, or can the government ban that, or that's a false basis from which to operate. The basis to operate is we are free individuals in a free nation, and the government has a limited authority to impose any limitations on us. And some of those limitations, that Constitution exists not because everybody agreed it should exist, but because we had a compromise that allowed people to feel protected enough to permit it to exist. One of those compromises that's viciously debated today is the Second Amendment. I can tell you it's very unlikely that we would have a federal government today without the Second Amendment, because the people who fought in the Revolutionary War and the people who had to take up arms and people who depended on those arms to protect themselves wouldn't have permitted it.
Okay, so Launch said ByteDance doesn't have any control over what the United States does with the company here. They gave over all the rights to say what the company here in the United States does to the United States. Right. Organic says, so just remember, if you order from anyone who is located in a foreign entity, you're at risk of having personal information being hacked for information to seize money and more. So she's bringing up a good a good fact that we do business with Temu and all kinds of companies that are owned by China and give them our information. But I think the difference there, Lydia, is it's not a user. I mean, yes, they do have some videos and affiliates and stuff, but it's not on the same scale yet as TikTok. And I don't recall, maybe it's similar. Does Temu ask for your contacts? It might.
So here's the issue with that, right? As long as China and the U.S. are not engaged in open hostility, then China's business interest, its tax revenue interest, all of these things align with very minimal activity in that area. The moment we get into active conflict, the Chinese government will put all of its resources into using all of that data it has to disrupt American business in any possible way it can.
Right, but she's saying so they're not picking on Temu. Temu might not have all the elements there yet that TikTok has. TikTok, someone can literally start a trend on TikTok and it takes off like wildfire. I don't recall that happening yet with Temu. And I don't think Temu has the same algorithm. I might be wrong because I don't know all that much about Temu, but that might be the reason you see some of those differences. However, if the government prevails on this one, I would bet that they would start cracking down on other Chinese owned entities. They did crack down on one in the past, which was Grindr. Believe it or not, Grindr was Chinese owned. And yes, yeah. He knows it. It was.
I know Chinese. What Grindr is, but I didn't know it was Chinese.
It was started by China, and the government forced them to sell.
Okay. Yeah. So another important part of our law and dealing with corporations as entities and their protection against regulation is the size and the scope of the ownership, as well as the size and scope of the business itself. So we have the concept of too big to fail when it comes to financial institutions. But then when an institution gets to the size that it's too big to fail because its failure would have such profound ripple effects throughout the economy.
That was Trump, by the way, when he went bankrupt 3 times.
Trump has never even come close to reaching too big to fail.
He
Sorry.
I thought he went to the banks and
not
said,
even remotely
didn't
close.
Didn't he go to the banks and say, it's not my problem, it's a you problem or something?
Trump is a poor billionaire, not a rich billionaire. So, and his businesses are all really privately scoped, very tightly scoped. He doesn't have any businesses that I'm aware of that have that kind of broad scope and economic effect. We're talking about banks, nationwide global banks. We're talking about trading companies, right, that trade stocks and these kinds of things. And when they reach that size, the government is permitted to impose additional regulation on them because the risk posed to the people in general is greater, right? And so that is in line with the concept of targeting TikTok and not the others. If TikTok is at a scale where it imposes greater risk, that also ties in with the ownership and how many people own it and how diverse their viewpoints are, and how removed the owners are from directly controlling the company. One of the elements of a corporation is that you get to hire a professional cadre of managers who run and operate the business without the direct control, daily, regular control of the owners. Now, the owners may vote once or twice a year, or their bylaws may say they vote on certain issues. But on the regular day-to-day basis, you have professional managers who may potentially own no stock in the company, have no ownership in the company, but they're responsible for the ownership or for the operations of it. So there are a lot of elements to what corporations are, how they function, and why they're set up the way they are.
Saying we're going to be in a position where we can control weapons, whether it's based on expression, whether it's based on anything.
Look at this record. I think it is quite clear that it current and potential future content on TikTok Incorporated. Here, you don't have just an act that is based on speakers and speech. It's triggered by speech. It's focused on a single speaker, TikTok Incorporated.
Justice Thomas, Justice Alito.
What if Congress, if there were nothing in this act about content moderation or covert manipulation? What if it was just about preventing was viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens. And they said, this is the worst, and we're going to require divestiture by this offender. Would there be a First Amendment problem there? And if you think there would be, what would the level of scrutiny be?
Yes, there would be a First Amendment problem if you had a law like this that was only focused on speakers, those who use user-generated content other than product, travel, or business.
Well, Congress concludes that this particular entity is the worst. This is the worst offender, and it happens to be an entity that is involved with speech.
If all you had, so I want to make sure I understand the hypothetical. The only provision you have is one that says this company has to shut down because of data security.
Right.
I would have a different set of arguments. I think it would still implicate the First Amendment, particularly where you have strong evidence that they were being targeted in part, at least because of their speakers and speech. Suppose Congress passed the law that you
posited. But you're changing the hypothetical by injecting congressional concern about it.
Okay, well, I'll put that to the side.
So what would your argument be? It would be an equal protection argument?
No, I'd still be saying that ACARA itself makes clear that where a law disproportionately burdens just a speaker, we have to subject that to scrutiny to suss out whether.
So, before you say that, I wanted to say the reason he's fighting so hard for it not to be like equal protection or something other than the First Amendment speech rights is because the First Amendment is better protected.
There's a lot it's protected in a lot more nuanced ways.
Yeah.
Even though if First Amendment is implicated or any fundamental right is implicated, the basic standard of review would be the same under equal protection. But I think what this justice is doing is trying to separate out the espionage elements of this, the inherent risk with a non-friendly country that we could very possibly go to war with, from the First Amendment question. And in the context he's raising it here, I don't think the government would have any legitimate interest whatsoever in picking best or worst offenders of speech and then punishing the worst offenders. I don't think that would fly for a second in a real case before the Supreme Court. And I don't think it would even be questionable. Right. But I think what his intent here is to separate out the logic from the espionage element of it, the potential military conflict issues.
The asserted interest is the actual interest. There, the asserted interest is in data security. I think I would have a couple of arguments under whatever form of scrutiny you wanted to apply, whether it is strict scrutiny or intermediate scrutiny in that context. I would say first that law is dramatically under-inclusive because it categorically exempts e-commerce apps that this record shows have comparable ties to China.
You say, I don't want to prolong this too much. You say this is not like ACARA, I think primarily because you say that the divestiture requires the new company to cease using the algorithm, right?
No, I think it's not like ACARA for a much more fundamental sense. ACARA involved a totally speech-neutral law. It didn't go after speakers. Prostitution in bookstores only. And I think that ACARA would have come out differently. There would have at least been, some kind of intermediate scrutiny, potentially strict.
All right, well,
that's the law that I think is your hypothetical.
Away from the hypothetical that I propose for the purpose of narrowing in on what your argument is. Understood you to say that that would not, because one of Congress's motivations was based on the content of TikTok. Am I wrong in that? Did I read your argument incorrectly?
Well, I think that I want to make sure I understand what you're saying. I certainly think that because one of the motivations was content, that is an enormously important fact. I was trying to answer your hypothetical where we were trying to take that out of the mix. And the different is because ACARA didn't just simply say no prostitution in bookstores. That's what your hypothetical effectively says. It says no data security problems in speakers in this particular speaker. I think that would trigger at the very least intermediate scrutiny.
Alito's sharp too, as long as it's not in his religious beliefs.
Justice, the Chief Justice asked you whether or not we've ever had a case where pure ownership was at issue. and not speech.
We're
And
not
I don't
sure
think
on
we've
this
had one like that. You're right. But I don't think that your gets to the essence of your argument, is it? The essence of your argument is you're being asked to divest because of speech, correct?
Correct.
All right. So if I get past that, if I go to Justice Alito's point, which is I don't think it's just about speech, it's about data control. If it's about data control, and assume, for the sake of argument, that I believe intermediate scrutiny applies to the data control provision, then your arguments would be different, wouldn't they? They would be under inclusiveness, they would be other arguments, correct?
Well, Your Honor, I think they'd be very.
Okay, I want to interject in here for just a second because they've used some key words. Under inclusiveness is one of them. Over inclusiveness is another. These are overbreath concepts, and overbreath is a unique situation, and that's primarily, probably exclusively First Amendment application, but it changes the equation of what I said very early on about rights being personal and you only being able to assert your own rights and not the rights of others, and those kinds of things. Overbreath changes that rule to a degree. Now, overbreath is generally applied as a last resort, not a first resort, but overbreath, if you meet the conditions, allows you to argue the interest of other people. So you don't even have to be directly affected by the statute. If you can prove it's overbroad, then you can get it overturned, even though it injures other people and not you necessarily. The rules are very technical. There's a lot of them, right? And there are different scenarios, whether they apply a rational basis or some form of enhanced scrutiny. Under rational basis, you bear the burden of proving there's no set of facts or circumstances under which the law can be legally applied. Under intermediate scrutiny, you have to show that there's no set of circumstances where the law can be applied to meet the degree of scrutiny. It's a tough burden to meet. I think we can easily meet it in family law, for instance.
Organic says we are the people. Where's Kavanaugh? I haven't heard him. Am I missing him?
I haven't heard him either. He has kind of a certain voice that you would recognize.
Where's?
I don't know.
Okay.
Similar, because I think the nature of our arguments work just as well under intermediate and strict scrutiny. If I could
All
unpack
right,
that a little.
no, I'm not going to,
Sure.
because we're going to run out of time, because we're going to need to figure out what intermediate scrutiny means. But I'm not sure it means what you do, which is I don't think any of our cases have ever suggested that we have to use the least restricted means under intermediate scrutiny. In fact, our
That's
cases
actually
have
not
said
true.
we have to use a reasonable means.
And if I could respond to that point specifically, I completely agree. It's not a least restrictive means alternative, Your Honor.
I think I
But you
have
do
that
have to
case
at
law that
least
says that.
Consider alternatives. Here, if the concern, let's take the data security concern, which you put your
Well,
finger on.
I know you want to keep going on, but I can't let you because I can't monopolize the argument, okay? But let me just get to the bottom of that, all right? You seem to suggest that Congress has to actually look at all of the alternatives and say no. I don't think we have a case that says that.
I am not
If from the record, it's clear that alternatives won't be adequate for whatever set of reasons, isn't that enough?
If the record were clear on that, that might be
Okay,
enough.
Now
But
I take
here
that.
on the
Now let me
key-
go to the next question and the last.
If-
And that's
if
the
I could, Your Honor,
intermediate
just one
scrutiny
sentence.
question.
If on the key less restrictive alternatives, they had actually considered them and said what you suggested, this would be a different case. But our point is that on the key, most obvious, less restrictive alternatives, a law, for example, that simply prohibits TikTok Incorporated from sharing any sensitive user data with ByteDance or anyone else, there's nothing in the record that suggests they even considered it. And that's why it
because
would
there's-
fail under even intermediate scrutiny.
We have a different problem, which is that the record shows that there is no sharing that could happen that wouldn't put the data at security. But we can go
That's
past that.
incorrect, actually.
No, because the NSA doesn't. What's
I'm
very
not talking about the NSA.
or even
Well,
anything
she
else.
gets
But
to
putting
see
that
what he doesn't
aside,
get to see.
One last question. Assuming
She probably has an unredacted
that,
copy or a much less
the
redacted copy.
covert manipulation issue is one, I think that what remains is, to the Chief's question and Justice Alito's questions, if the covert manipulation is a concern, then the question becomes, what kind of burden does it put on TikTok USA? And I think your point is that that requires strict scrutiny because it doesn't permit them to speak to the Chinese government through the algorithm and promote whatever speech it wants to promote through the algorithm.
It
Correct?
doesn't permit them to speak to the American public through the algorithm.
Right.
And promote whatever type of speech they want to promote on the algorithm. And I also think that this covert manipulation is a little bit odd. They're not concerned just with covertness. If all you were concerned
I'm going to
with
ask
was secret-
she about that. How do you disentangle the two things?
Thank you, Your Honor.
Justice Kate, Justice Gorsuch, Justice Kavanaugh?
Just on the data collection interest, I think Congress and the president were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people, people who a generation from now will be working in the FBI or the CIA or in the State Department. Is that not a realistic
So this is Kavanaugh, you
assessment
guys.
by
I was wondering
Congress
where
and
he
the
was.
president of the risks here?
Well, Your Honor, I'm not disputing the risks. I'm disputing the means that they've chosen. One way, the most direct way to address that, all of this user data sits on data servers in Virginia.
Okay, so that's an important point. When you talk about constitutional scrutiny under substantive due process, you basically have three issues, three sets of tests that could be argued they're two sets of tests or a set of four tests. But essentially, you have to have a compelling interest or a sufficiently narrow interest if it's intermediate scrutiny, which is generally discussed as substantial, which, by the way, the state's interest in serving the best interest of your child is merely substantial, not compelling by Supreme Court precedent. So it can't justify all the things they do. But the three elements is, first, you have to have the interest the government is trying to serve. That interest has to be legitimate under rational basis. It can't be arbitrarily determined. And then the authority they establish, the statutes or the equitable authority of courts they assert, has to be written with precision relative to the degree of scrutiny that they're applying. So in strict scrutiny, it has to be narrowly tailored, meaning it affects only the rights that are absolutely necessary to achieve the compelling objective and no others. All right. So if it goes even slightly beyond what's necessary to meet the objective the government asserts, it's done. It's over. It fails. Right. Intermediate scrutiny has less tight restrictions, but they still have precision in how those have to match up. And the exact same test, and that's the authority test, I call it. The courts don't really label it, but that's the authority test. They'll sometimes say strict scrutiny and only mention that part of it, but strict scrutiny is really more, and that there is the ends means test. And that's when he said, I'm arguing the means. That's a specific kind of argument. And what he's saying is that the government fails because the means it applies to meet its objective, its goal, do not pass the appropriate test. Right. And under strict scrutiny, it has to be least restrictive means. If there exists a means available to the government that can achieve the compelling objective that are less impactful on rights, then the government has to take that option. It cannot, under any circumstances, take the more restrictive option if the lesser restrictive option will suffice. Okay. And then intermediate scrutiny, there are variations on that. One of them in the speech context is in content neutral issues. They will say, and you've heard them discuss around this, there has to be available other options to achieve the same speech. The speaker has to have other viable options available to them before the government can restrict under intermediate scrutiny in the way they want to restrict.
And TikTok's lawyer keeps arguing there is no other algorithm like this. Remember earlier in these arguments, one of the justices, I think it was Sotomayor, said, but you can go choose from the best algorithms that are out there available. And he's arguing that no, there is nothing like this. He didn't say it exactly like that, but that's what they're getting to.
And his argument is correct on that. I'm
Yeah.
coming from the technology background. These are highly customized, highly secretive and unique
And he
algorithms
gets
to each
into
company that
that.
change constantly. The question in my mind that I argue is that algorithm is not speech. That algorithm is a facilitation of the phone system. It's not of how I'm able to have a phone number and connect with people.
Yeah, they'll
It's
go into
not.
it more.
That's not TikTok speech anymore than my having a phone number is AT&T speech.
They'll go into it more a little bit. David Percival, welcome in. David says, if we exchange liberty for a false sense of security or safety, we deserve neither.
Benjamin Franklin, one of my heroes.
Thank you, David.
My first company was called Franklin Tech.
Yep, it was. Adventures of Pam says, I realized and accepted 12 years ago that companies have my data. They know every step I take everywhere I go. Not to mention you show your license plates on social media, so and your whole property.
Yeah, we need some fundamental evaluation of who owns that data and how that data can be applied when you give it to people. There's some very, very bad law out there by the Supreme Court based on those previous justices having a very, very poor understanding of technology, where they say that data that you don't have an expectation of privacy when you give your phone data and who you call and your phone logs to AT&T, or they collect that data, and you extend that to the current day in cloud computing under those old precedents, and to my knowledge, they haven't been changed yet. You have no expectation of privacy in your cloud storage that you have with Google or Microsoft or anybody else, according to those old precedents, which were bad law in my opinion.
But you guys are going to hear later in this argument, you're going to hear this argument switch a little bit to the government's actually, and some of the justices are going to call them out on it, that the government's actually concerned with TikTok's ability to activate people. Okay, so you'll hear that in a little bit.
By Oracle. I'm not talking about the National Security Agreement. What I'm talking about is a law that simply says to TikTok Incorporated and its U.S. employees, you cannot share that user data with anybody. You can't give it to ByteDance. You can't give it to China. You can't give it to Google. You can't give it to Amazon. You cannot give it to anybody under threat of massive penalties. They never even considered that most obvious alternative. And so whether you apply intermediate scrutiny or strict scrutiny, it's not a least restrictive means test, but you got to at least consider the most obvious alternative.
So you acknowledge the risk that Congress and the president were concerned about. You're just saying the means they chose to address that risk were incorrect.
So I
not permissible.
I certainly acknowledge the risk, but I think there are lots of reasons, not just the one I just gave, but there are lots of reasons why that risk still can't justify the law. When it sits alongside of the impermissible covert manipulation risk, I think it falls under Mount Healthy. It's no different if they came in and said, we passed this law, one for data security.
I understand that. Collection, that seems like a huge concern.
Again, it is a concern, two responses. First, it can be addressed directly. The reason why there's no evidence in this record about whether that kind of direct prohibition on TikTok Incorporated user data with anybody, including ByteDance, the reason why the record is devoid of any evidence of that is because Congress never considered the other side of the balance. And the minimum that Congress has to do under the First Amendment, it's got to at least consider the consequences of shutting down a speech platform used by 170 million Americans against the benefits of an alternative, like simply saying that TikTok's employees, essentially you're going to get massive fines, potentially jail sentences, if you share any of that sensitive user data with anybody, not TikTok, not ByteDance, not China, not anybody else in the world. Yet there's nothing in this record that suggests they even considered that alternative.
What happens after January 19th? You lose this case. Can you just spell that out?
At least as I understand it, we go dark. Essentially, the platform shuts down.
Unless there's a divestiture.
Unless there's a divestiture, unless
Presidential
President
extension.
Trump exercises his authority to extend it by not, but he can't do that on January 19th. On January 19th, we still have President Biden. And on January 19th, as I understand it, we shut down. It is possible that come January 20th, 21st, 22nd, we might be in a different world. Again, that's one of the reasons why I think it makes perfect sense to issue a preliminary injunction here and simply buy everybody a little breathing space. This is an
What do you
enormously,
mean by shut down too? Can you just spell that out?
so
If you
the
can.
the app is not available in the app stores. That's at a minimum. But in addition, what the act says is that all of the other types of service providers can't provide service either. Now, there's enormous consequences for violating that for the service providers. So essentially, what they're going to say is that, I think we're not going to be providing the services necessary to have you see it. So it's essentially going to stop operating. I think that's
So it sounds like he's talking about things like cloud
which again
storage
is
and,
why,
and
a
data
short
centers and those
reprieve
kind of
here
things.
would make all the sense in the world. It's an enormously consequential decision. And I think all would benefit if it weren't necessary.
Thank you.
So very few companies own all of their
So I
infrastructure.
just want to, just kind of following up on Justice Kavanaugh's questions. Let's say I agree with you that some level of scrutiny applies, and I'm trying to figure out which level of scrutiny applies, and I'm trying to figure out if there's content discrimination. And let me ask you a different question than I did before about the algorithm. I mean, you keep saying shut down. The law doesn't say TikTok has to shut down. It says ByteDance has to divest. If ByteDance divested TikTok, we wouldn't be here, right? If ByteDance was willing to let you go and willing to let you take the source code with you, that would be fine, right? We would not be here.
Well, Your Honor, if ByteDance divested, then the law wouldn't fall on TikTok. But the law, not ByteDance.
But that's
the
because of
law requires
ByteDance's
TikTok to shut
choice,
down.
right? I mean,
Well, it's-
this is like Justice Kagan's point. I mean, I'm trying to figure out how we account for the reality of third-party choices and the choices of third parties that the whole reason for the law being passed in the first place.
Yeah, Your Honor, I still don't, I think that the way the analysis works is step one, is there a First Amendment violation?
Right.
Step two, you get to the question that we're grappling with. What standard of scrutiny do you apply? Typically, what you do
He's
is
skipping
you
a step
ask,
there.
is this law content-based? Is it content-based based on its face? Is it content-based in its decision? Here, we know it's content based on its face because it says what it says. We know it's content based in its motivation because the government concedes it's content based in its
Well,
motivation.
that's not quite what I'm asking. I mean,
I
let's
think
see,
I-
that's the dispute between
Yeah.
you and the government is it content-based if it's about divestiture and not about telling TikTok what content it can display on the platform?
And I think it has to be because I think that really goes to the first question. Does the burden fall on the speaker? If the burden falls on the speaker, that triggers the speaker's First Amendment rights. But the law is in fact content-based, whether it comes in the form of a divestiture or something else. When the law specifically says it's content-based, we're worried about the content on the platform. And when the government tells you that one of our reasons, one of the things that we're worried about is TikTok, not ByteDance, but TikTok Incorporated and TikTok in the United States will, absent the divestiture, have a mix of content that we find objectionable. They will mix around their videos in a way that is too pro-Chinese or too anti-American.
Okay,
And that
let me-
is TikTok, the platform.
Let me just ask you one last question. Why is it impossible to divest in the 270 days, even assuming that the Chinese government hadn't said you couldn't?
Sure, and this is the exchange I was having with Justice Gorsuch. There are two basic reasons. The first is that the underlying source code, that's the source code that comes in here and then has to be converted.
But
and
that's what
executed
Justice
with
Gorsuch
those.
said, just not ever. So it's not really that you can't do it within the time frame. It's that you really couldn't ever divest because you never are going to get the source.
So, well, let me unpack that a little bit. No, it's that with the underlying source code, it takes a team of engineers to update and maintain that. It would take us many years to reconstruct a brand new team of engineers to do that with respect to the source code. With respect to the sharing of content, that was the different reason. In theory, we could kind of send our salesmen around the world, go to Ireland, go to Finland, go to every country and say, look, you used to automatically get our content, but now you got to separately sign up
Okay,
for
so
our platform.
last point, let me make sure I understand what you're saying. It's not that you couldn't execute the disentanglement. You could say we're independent. You just can't recreate TikTok in any kind of way.
Well, I think that any new TikTok would be a fundamentally different platform with different content, which is yet another reason why I think this is a content-based restriction that falls directly on TikTok incorporated itself in our platform.
Yeah, from a technology and
So
business
this,
organization perspective, he's
back
probably
to
correct.
Some of the questions that Justice Barrett and Justice Kagan asked about the sort of threshold issue that you point out, which is there a burden on the speaker? I'm trying to understand what the burden is that you are articulating and whether it really isn't about association and not speech.
There we go.
You have in your brief some cases that talk about American speakers being free to choose whether to affiliate with foreign organizations. And the colloquy you had with Justice Kagan made me think that what you're really complaining about is the inability to associate with ByteDance and its algorithm. That it's not really about, if TikTok came up with its own algorithm or bought an algorithm from some other company or devised it or whatever, this law would have nothing to do with them from your perspective. But the problem I think you're articulating, and this is, I'm seeking your clarification.
Sure.
The problem I think you're articulating is that you want to use ByteDance's algorithm and therefore associate with ByteDance, and Congress has prohibited that by requiring divestiture. So isn't this really a right of association case under the First Amendment?
I think it's both, Your Honor. I do think that that's a component of it. We want to use the algorithm that we think reflects the best mix of content. That's the algorithm that reflects the best mix of content. What this law says is we can't do that unless ByteDance exercises a qualified divestiture. But I also think more directly what this law does is it says that TikTok Incorporated, if ByteDance doesn't exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok were to post divestiture or whatever, pre-divestiture, come up with its own algorithm, right? Then when the divestiture happened, it could still operate. It doesn't say
that would take
that
would take years and massive
that also
investment.
underscores the content-based nature of the restriction.
No, but the fact that that's true suggests that you're wrong about the statute being read as saying TikTok, you have to go mute. Because TikTok can continue to operate on its own algorithm, on its own terms, as long as it's not associated with ByteDance. So isn't this really just all about association?
Your Honor, I think it is partly about association, but I'm going to take another shot at explaining why it's not just about association.
Okay.
In
well,
practical
let me just
operational
take you down
terms,
the
that's not
association path
possible.
For a second, because if it is about the association of TikTok with ByteDance, then don't we have cases that seem to undermine your view that Congress can't do this? I mean, I thought we had cases about Congress prohibiting association with terrorist organizations, prohibiting association with foreign adversaries. And so why doesn't this fall into that kind of group of our jurisprudence?
Well, at least as I understand all of those cases, they applied strict scrutiny. The material support statute most definitely applied.
And ultimately upheld the law, so fine.
But sure, and I think if we go down the strict scrutiny road here, I don't see that this law can possibly be satisfied under the interests that they assert here. But I do want to emphasize why this is also about TikTok speech. Even under your hypothetical where theoretically they can say something differently than they are saying today, that in and of itself is a direct restriction on TikTok speech. They can't engage in the speech they want to engage in. They have to engage in a different kind of speech, the speech they don't want to engage in. That is a direct burden on TikTok Incorporated speech.
All right, I think I understand that argument. Let me ask you a question about your colleague.
All right, so I want to interject in here two things. First, the First Amendment does not nothing in the First Amendment, in the text of the First Amendment, says anything at all about association. The only reason the association is protected, and this is held in cases like Griswold versus whoever the heck Griswold is. I don't think there's any other Griswold out there, so you can easily find it. But what they say is that it is impossible to speak with someone if you don't first associate with them. And if the association is for the purpose of expressing any type of communication, then it's protected by the First Amendment as being necessary to fulfill the protections of the First Amendment. So it's kind of an indirect, what they call an umbrella right to the First Amendment. It's not directly enumerated in the Constitution, but remember the Bill of Rights does not enumerate every right that we have, and the Ninth Amendment very clearly says that it is not intended to encompass every right that we have protected against the government, even though the courts love to just ignore that. But the founders believed that we had vastly more rights than what the current court is willing to even recognize. All right, so when they talk about association, they have to be talking about speech, because the right of association only exists as a means of facilitating speech. And that's very important in the family law context, because there are two types of association. There's intimate association and expressive association. But in reality, there's only one type of association. That's expressive association, because intimate association characteristics still can only exist through expression. If you're going to have an intimate relationship with your child or your marital partner or whoever else, other family members, you have to express that affection and you have to receive that affection. Otherwise, it doesn't exist. Right? So it's all basically about speech and expression when you're dealing with association. And the other thing, they keep mentioning is the burden. So there is basically a separate line of legal reason, constitutional reasoning, kind of different and apart from the line of constitutional scrutiny with least restrictive means and those things. And it's called the undue burden test. And it came about in abortion cases. I think it came about in one of the Planned Parenthood cases that's very famous and that we use quite a bit, because the abortion cases, of all the cases, go more into detail about the nature of family and family relationships and how that impacts your rights than pretty much any other case out there. So they're a gold mine for family law. But one of those cases goes in and defines that standard of constitutional review. It's called the undue burden standard, and it's kind of convoluted and mixed up. And Kansas Supreme Court just rejected it altogether and says we just go by strict scrutiny for everybody except parent versus parent custody suits. Everybody else in Kansas gets strict scrutiny on all their fundamental rights, regardless. There's no intermediate scrutiny at all. It's either rational basis or strict scrutiny, except in family law where there's no standard. All right, so let's let them continue.
With Justice Kavanaugh, did I understand you to concede that there is a compelling interest and that the problem is really tailoring? I mean, you said, I understand the risks. I don't hear you suggesting that the risks don't exist. So it sounds like we've gotten past, even if we're in strict scrutiny world, we've gotten past the compelling interest part of this.
No, Your Honor. What I was saying is that all you had standing alone were the data security. That would be a different case. Here, when you have the content manipulation sitting right alongside of the data security, that taints the data security rationale. If Congress came in and said, we're passing this law for two reasons. One, we really care about data security. And two, we hate the speech on TikTok. The data security wouldn't.
Why don't they talk about espionage? I don't understand that part.
I understand, but why you're equating, we don't want foreign adversaries to be able to manipulate the content on this platform. You're equating that with we hate the content. And I'm just trying to understand why. Because content manipulation is by definition a content-based distinction. Look, everybody manipulates content. There are lots of people who think CNN, Fox News, the Wall Street Journal, the New York Times are manipulating their content. That is core protected speech. That's why they put so much weight on this.
That's not the speech of others.
Right, but that analysis is just about content based versus content neutral, and therefore whether you apply strict scrutiny. I'm in the strict scrutiny world. Okay. I'm assuming that you're right, that strict scrutiny applies. And now prong number one in that world is, does the government have a compelling interest? And so I'm trying to understand why the government's argument that we have data manipulation concerns, which I understood you in colloquy with Justice Kavanaugh to say is a risk, and we are concerned based on what Justice Gorsuch says when he's looking at the facts, that the government contends that there's this real problem with this foreign adversary doing manipulation in other places. Are you saying those are not compelling government interests?
I am 100% saying that content manipulation is not just not a compelling governmental interest, it is an impermissible governmental interest. You could not.
So the standard of what is compelling and is what's not basically turns around whether it's necessary to be achieved. So the best interest of the child is not necessary to be achieved, because you cannot, if you have 2 children or 5 children, you can't possibly meet the best interest of one child without subordinating the best interest of the other 4. And if you focus on any part of your life, then that takes away from your child, and therefore you can't meet the best interest of the child if you meet your minimum standards of health and mental saneness, right? So best interest is not necessary to be achieved, nor what he's saying are those assertions that the government is making. That's not necessary for them to achieve them. They may be important, but they're not necessary. So that gets them into intermediate scrutiny.
Go to CNN or Fox News and say, we're going to regulate you because you're manipulating the content in the way that we don't like. That is per se impermissible.
Okay,
That
can I
is
just
why-
ask you one last thing? You say with respect to the tailoring issue that disclosure you think is a possible more narrowly tailored way of handling some of this. And I guess I'm just wondering whether disclosure under this court's case law and the law of other lower courts doesn't carry its own First Amendment complications. That wouldn't we have compelled speech problems if disclosure was required in this situation?
Sure, Your Honor. Now, look, I might think so because I think that the factual predicate is wrong, but they think the factual predicate is right. And if the factual predicate is right, then there are no First Amendment problems at all under Zauder and the cases that you're suggesting. And that underscores the larger problem here. Not all disclosures are perfect. I'm not here to argue that they are, but you've always got to consider what the alternative is. And here the alternative is shutting down one of the largest speech platforms in America. The reason there's no evidence in this record as to disclosures is because Congress never even undertook that balancing in the first place.
Thank you.
The bare minimum that has to be done before we take an unprecedented step of shutting down the voices of 170 million Americans.
Thank you.
Thank you, counsel.
So he's on much firmer ground when he's talking about the speech of Americans on the platform rather than the speech of the platform itself. And he's doing that he's changing that focus for other reasons, because
Mr. Fisher?
if they
Mr.
say
Justice,
the platform
and may it
has
please
a
the court,
voice, then that
wholly
gives them
apart
all
from
other,
the
a whole
company's
nother
legal
set
interests here,
of
restricts the rights, the First Amendment rights of American creators to participate and speak in what the court a little less than a decade ago called the modern public square. And what you might say today is the most vibrant speech forum in the United States of America. And the act, therefore, is inescapably subject to strict scrutiny because of the First Amendment implications. And the act fails that test, and indeed any level of scrutiny under this court's case law, because the act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with this implication and its use of the phrase national security in this context. It simply doesn't change the calculus. Throughout our history, we have faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow down our
our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court's questions.
How exactly are the creators' speech being impeded?
So two ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates text, images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other
But it
Americans.
doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or there will be other national security problems with someone who's not a citizen of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership.
So I want to point out something real quickly. When you hear Justice Thomas speak, you need to understand Justice Thomas's position. His position is the vast majority of case law under due process and equal protection is wrong and is invalid. That's his position. And he desperately wants someone to challenge the fundamental way in which the court addresses those substantive issues. All right. And nobody will, because that would be just a nightmare. And I think he's wrong. But his baseline is always that the government can do far, far, far more than the court permits it to do. And it verges on, if not outright, statism. Scalia was the worst about this, but Scalia acted to dramatically protect anything that our founding fathers, people he considered better than himself, wrote down. If they wrote it down, he would go to war to protect it. But except for the Ninth Amendment, he wouldn't protect it any way, shape, or form, because the Ninth Amendment says we're basically free. We basically have a vast number more rights than what are written down here. And we only wrote down the most important because we know government's going to try to screw with these. And as we can see, that's what they're doing today. Right. So you have to understand Justice Thomas's perspective. Now, so long as we don't overturn that baseline of how we interpret the 14th Amendment, Justice Scalia is going to follow precedent, stare decisis, and do primarily the right thing. Most of his decisions, you go away from the Second Amendment nonsense, where I'm pro Second Amendment, but his logic is just absurd. You get away from that, and then he pretty much comes down with the right things. In family law, in Troxel, he said the Washington government had zero legitimate government interest in interfering with the decisions of a fit parent. None. That is gold for us, right? And that's the way it should be. But he also says, in that same opinion, because nobody's challenged the underlying substantive rules we apply, I'm applying stare decisis. He didn't use those exact words, but the phraseology you get used to when you read his stuff. So keep in mind the nature of Thomas is that he is a statist, but he's also a strict rules follower, other than financial rules, reporting rules. And he is going to do what he considers his betters told him to do, like Scalia. And so if our founding fathers wrote it down, he's going to treat their words like gospel. Except, again, for the 19th Amendment, which scares him because it gives too much individual freedom.
And this was talked about a lot in the first part of the argument here. So let me be very clear. The American creators have a right to work with the publisher of their choice. So imagine somebody wanted to work on post speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform, and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with.
Using that argument, you could have said that about the breakup of AT&T. You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, I think that you have to dig a little deeper than that, Justice Thomas. It's not mere foreign ownership, and it's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online media publication is the essence of the viewpoint of that publication. The current owner of X, or the current owner of Fox News, or the current owner of MSNBC has a particular perspective, and working with that particular platform is shot through with the ownership from top to bottom.
But why couldn't Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States? I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right. So I'm glad you're bringing that up.
That fits right in the
when it comes
definition
to
of
national security, you're right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations
treason.
that pose a clear and
That's how
present
treason is
danger
defined
to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine U.S. leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most.
What he's saying is absolutely true for friendly nations. If it's an adversarial nation, particularly if it's a nation we're in open war with, that we've declared war on, then it becomes treason. And treason, by the way, is the only crime defined in the Constitution. And it requires two people to testify that you gave aid and comfort to the enemy. Well, that's speech. Okay? So the Constitution itself limits speech against foreign adversaries. So that complicates things.
Tony said, and welcome in, Tony. I wasn't in here. Ron can't see the chat. So
I'm too blind to read that.
Yeah, he said a lot of people have turned to TikTok over the news because Americans' voices are so big on the platform. So I think he's saying they're going to people on TikTok to find out what's going on. Is that what you're saying, Tony? And Organic Silver Moon says to get a better winning leg, saying discrimination to U.S. citizens speech, but many have been jailed for speech. Right to keep and bear arms, Second Amendment. So she's just saying many have been jailed for exercising their rights. Okay, cool.
Directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable from what's happening in Holder. So can you just say a little bit?
It goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security in the case is over, or you don't get to associate. You have to dig underneath what is the national security claim. And what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it, is it terrorism? Is it where our battleships are located?
Justice Kavanaugh.
So the court talks about the same plane of generality as a rule for how and why it applies narrow tailoring and least restrictive means, which are essentially the same test, just applied to different things. One's applied to authority, the other's applied to the means that you use to implement that authority. But they both ask important questions about the government's justification versus the impact on the individual. And as I was saying earlier, and I know a lot of people came in after I said these things, but the government cannot set up a broad justification like best interest or health, safety, and welfare to infringe and say that's a compelling interest to infringe upon your very specific rights, because that's arguing two planes of generality. And when you do that, you predetermine the outcome. Those are the words of the Supreme Court, is that using too broad a plane of generality or unequal planes of generality predetermines the outcome. So if you want to rig the outcome and say, well, best interest is a standard we apply, then you've just rigged the outcome according to the Supreme Court logic, right? So all this that they're getting at is getting down to apples versus apples, not apples versus a truckload of apples.
Presented a number of potential risks, right? With foreign adversaries using covert manipulation of the data platforms that are being used by youths today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
I get it. So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok that is anti-democracy, undermines trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now, there's a secondary argument the government makes, and we say you don't even get to that because once you have an impermissible motive like that, the law is unconstitutional. But even if you could get to that, Justice Jackson, I do grant that data security and the way Justice Kavanaugh spelled it out is compelling. That is compelling. Don't have to look any further than the divestiture provision itself, which says that the content recommendation algorithm cannot be used in the future. Well, that has nothing to do with data security. So the core feature of the divestiture provision is going at content manipulation, which I said is impermissible. You can't uphold that under data security grounds. And the rest of the act, when you look at the covered companies provision, Justice Jackson, if this were primarily a data security law, what you think you'd find is what kind of data is procured? How is it stored? Is it shared? Those are the things you think you'd find under covered companies, but you don't find that. What you find is, are text images shared? Is content being shared between users? Is it being created and posted in a social media platform? So I don't dispute for 1 second that data security is a very important thing, and Congress in this very law regulated data security in other ways with data brokers. That's perfectly permissible. But the question before you today was narrower. The question is this law before you sustainable on data security grounds? And that answer has to be no.
Congress doesn't care about what's on TikTok. They don't care about the expression. That's shown by the remedy. They're not saying TikTok has to stop. They're saying the Chinese have to stop controlling TikTok. So it's not a direct burden on the expression at all. Congress is fine with the expression. They're not fine with a foreign adversary, as they've determined it is, gathering all this information about the 170 million people who use TikTok.
Well, again, Mr. Chief Justice, if I may, let me separate where you started, which was the content manipulation, and then go to the data security part of it. So,
well, the first part of it is not. I'm not talking about the content manipulation. I'm talking about the content harvesting.
When you say content harvesting, do you mean people's data?
They've got all the information, whatever algorithms they want, that has access to the personal information or information that is not readily available about 170 million Americans. And in 10 or 15 years, when those people grow up and have different jobs in different places, or whether they're going to use it now.
Or in warfare.
That, at least as I look at the congressional
that is a warfare tool.
record, is what I was concerned about.
Well, I think
and they're not concerned about the fact that it is available. As I said, the remedy is just somebody else has to run TikTok. So they're not concerned about the content. They're concerned about what the foreign adversary is doing.
So if I may, I think to answer your question properly, I think I have to separate two things. One is the content recommendation algorithm. And that's what I was speaking about a moment ago. That has nothing to do with data security. That doesn't itself procure data. That just determines what videos people see on their feed on TikTok. As to that, I think the answer is inescapably that the government and Congress itself was worried about content. The government itself is here saying national security. So like a mix of cat videos or dance videos doesn't affect national security. No matter what happens, the only thing that can affect national security are the substance of those videos. And when the government's pressed in its briefing, it outright tells you that. It says, what we're really worried about is sowing doubts about US leaders, et cetera. So let me turn then to data security. Yes, there were various congresspersons, and in the record that we have in the DC circuit, there were conversation about the problem of data security here. As I said, I don't dispute that is a valid governmental interest. So I think you addressed whether that alone can sustain the act in two steps. First, you would ask, if you have an impermissible motive and a permissible one, can we sustain the act based on the based simply on the permissible motive? And I think for the reasons Mr. Francisco said, and we lay out in our brief, that alone, the answer is no under Hunter against Underwood and other cases. Even if you could get just to the data security question, again, you'd have to ask the question, would this law have been passed by Congress for data security reasons? Because you're being asked to uphold a law based on that single governmental interest. And when you look through the provisions, like the content recommendation algorithm provision, like the covered company provisions, the answer is no. And if you're still in doubt on that, just go back to the under-inclusiveness problem. Would a Congress really worried about these very dramatic risks leave out an e-commerce site like Temu that has 70 million Americans using it and every bit the connection?
Does Congress have to go all or nothing on that? I mean,
it doesn't have to go all or nothing.
They isolate a particular
Look organic about it,
problem. They might be getting to what you're talking about next. Who knows? But you're really sitting up there and saying Congress would not pass the divestiture law if data security were the only interest.
So I'm saying it would not have passed this divestiture law if data security were the only interest. It's very curious why you just single out TikTok alone and not other companies with tens of millions of people having their own data taken, in the process of engaging with those websites, and equally, if not more, available to Chinese control. So I'm not trying to say that Congress has to do everything at once. I'm trying to say that once you've concluded that
we get massive benefit from those sites.
Okay.
Just on one of the things I do, again, 25 plus year technology and technology management background. And one of the things I'm focused on now that I'm only doing family law and our homestead is automation for my homestead businesses, Internet of Things, right? And so all of those little circuit boards that do vital things, you can get from these Chinese companies for pennies that cost hundreds of dollars to buy. If you buy the industrial level quality that a large corporation is going to buy to monitor a process that makes them $1 million a day, they're going to spend hundreds of dollars on their monitoring circuits, right? But I'm not going to do that for my tiny little homestead, but I still have monitoring needs, right? One of the things we do is a worm business, and those worms are very, very temperature sensitive. I want temperature monitoring on them 24/7 tied into my computer with alerts. Well, I can do that through Temu, and what's the other one? The other one, they sell these circuit boards the very good quality circuit boards, and there's very little to really screw up in these some of these more basic circuit boards for pennies. You can buy dozens of them for a few dollars. That is game changing for small businesses doing automation, technology automation, robotics, industrial control, all of these things.
With that argument, TikTok has been game changing for content creators. And so you're making an argument like, oh, you don't want that taken away. Well, that's what everyone that's using TikTok has been saying.
What I'm saying is the things you have to balance. I'm not saying I want them to take it away or not. I'm saying that we get tremendous economic benefit from China.
But David's saying if China's an adversary or an enemy, then declare it, and our companies will not have to honor patent agreements, he says, and having pseudo and limitless wars with undefined enemies such as terror, we lose all structure.
Yeah, if we were five and life was black and white, that would work. But life is not black and white. They are an enemy. They are an incredibly necessary trading partner, and if we stop trade with China, it would decimate our economy for a decade at least.
It's kind of like Russia and Germany. Like Germany's dependent on Russia with the power, the energy, right? If we would have to put infrastructure, which I know Trump has focused a lot on that, like American made, but we're not there yet. We don't have that infrastructure, and nor would we ever be able to make it as cheap as China because we don't have those kind of wages, for one. So it's just
a lack of laws and regulations.
So there's so much that.
So something to understand about geopolitics and dealing with dictatorial regimes like China and Russia. Our overall grand strategy for defeating these countries is economic engagement. Number one, when you trade with someone, you rarely ever go to war with them, and the reasons to go to war have to be massively more important than the trade. We've made a purposeful strategy to engage both Russia and China, and particularly China, in economic engagement to create economic ties and economic interdependencies, which would weigh against any kind of open conflict. And what we see with Putin and with this current guy in China is nothing more than a natural retrenching before something dies. All right. They are trying to undo all of this economic entrenchment. They are trying to go back to their imperialist ways, which simply won't work in our modern interconnected world. And what he learned very quickly in the last couple of years is when you try to do that, your economy takes a massive hit. Your people start hating you in a massive way. They've got a taste of the good life. They don't want to go back. Right. And so what that does is reins in those dictators in a way that nothing else will. Right. And at some point, once the economics interconnection is so strong, the dictatorial ability of these regimes will simply fall apart. They can't be maintained over time without an active enemy. And if you're engaged in strong bilateral trade, you can't make that country an enemy effectively. So there is strategy behind everything they're doing there, and you can't, if you shut it off, it hurts us more than it hurts them, because that empowers them to be dictatorial and act like the countries we don't trade with, like Cuba and North Korea.
So Organic brings up a point. She says, I built my computers, I bought American, it costs more no matter what. And some people can do that, but what he's saying is on a mass scale, it would drive up so many costs, because you might be buying American, but a lot of our corporations may not be buying all American because they got to be competitive, right?
You didn't make an economic decision. You made an emotional or a value-based decision, or a nationalistic decision that, from an economic standpoint, remember, I went to graduate school for economics, so I have a pretty firm understanding of these principles. From an economic perspective, if you want to raise the economy for everybody, free trade is the only way to do that. Expansive, unlimited free trade, because the only way you create value is when two people freely trade. If that is the only way that we get a bigger pie. Okay. Otherwise, you're all fighting over a fixed pie, or a pie that's going to shrink because nobody's building it anymore. Right. So every freely entered exchange creates greater value in the world. That's why we have people with $400 billion like Elon Musk, not because we're fighting over the pie that was smaller than that 50 years ago. Right? It's because the pie has got so dramatically larger as the world is integrated, and we've got 8 billion people all engaging in free trade constantly, day in and day out.
Manipulation, for the reasons I've said, as a matter of our history and tradition, has to be impermissible.
Is there another site like this one that covers half the American population?
Yeah, population.
I don't think, just by way of sheer numbers, Justice Sotomayor, that the answer has to be no, but 70 million seems like a lot.
170 million is a lot, but put that aside and then go to the
Facebook
next
has billions.
question, which is, how
Just
many
in
of
America,
these
there's only
sites have
400 million here.
all of the data collection mechanisms that TikTok has? From what I understand from the briefs, not only is it getting your information, it's asking, and most people give it permission to access your contact list, whether that contact list has permitted them to or not.
That's why I brought
So
up
they can now have data
That opens the
about
door to
all of your
espionage.
contacts and anything you say about them. How many other sites gather information by keystrokes?
And
to be able
just
to
for the
do voice and
just for the record, it's important to realize, because it doesn't get much attention outside of the IT community, but the largest ever, most massive, most effective hacking of multitude of internet systems and accessing data from people like Trump has been done by China in the last couple of years on an incredibly massive and effective scale. And so China is truthfully engaged in real-time warfare right now on the technology front. And they're using this kind of information that's shared between people to get the connections necessary to facilitate those kinds of attacks on our infrastructure and attacks on our computing systems. This is a massive, massive real problem. It is so bad that the federal government has very recently completely flip-flopped on the idea of encrypted communications and individuals having encrypted text messages and encrypted messages on Facebook. And now the federal government is actually recommending that everybody have that encryption. And if you use Messenger, you'll notice that they've been increasingly encrypting all of your chats. It's going to take them a while to get them all done, but the goal is to get them all done. This 2, 3, 4 years ago, the government was polar opposite, saying, no, we don't like that because we can't hack into your systems. We can't spy on you. But now that China's doing it on such a massive scale, that's relevant.
Finger ID information if they choose. And there's a whole lot of data stuff that was discussed in the brief that I don't think any other website gathers. So wouldn't this be a unique site if I viewed the evidence that way? How would this be under-inclusive?
Justice Sotomayor, I don't think a lot of the suppositions you're making actually bear out. And as Justice Gorsuch was pointing out, one of the obviously the real challenges in this case is it comes to you without an ordinary trial record compiled and all the rest. So we have only limited amounts of information, but absolutely these other websites are taking much the same kind of information, if not more. And as to the contact list thing, I think that points out one other aspect of this. That is voluntary decision by an American user to share that information. In the Riley
but
case.
Not informed.
Well,
Even if
that could be solved.
but
If you don't think it's informed, that could be solved by
no,
a
that
warning
can't
or
be,
disclosure.
because for the United States, the threat of using that information is what is at issue. It's not whether the user thinks it's okay.
Well, she's wrong, because I just told you of the informed nature of it and how a lot of people know a lot about it. That's just a paternalistic BS argument.
Hey, Jay, I wanted to say I'm glad you're here. Jay's from Family Court. He said Family Court's messing with his children, his life up real bad. And I said, we're also talking about how this correlates with family law. So it's really important, Jay, that you understand a lot of these concepts like under-inclusive, over-inclusive, overreach, and these balancing tests and things that these justices are talking about. That's why we're streaming it on the Family Court channel, because you don't know what rights or how they're infringing your rights if you don't understand. These are basic terms that they're discussing in here, and it ties directly to a lot of the things they do in family court.
So let me give you some examples. Best interest of the child is under-inclusive because the state is asserting the necessity of protecting some children from their fit parents' lawful exercise of constitutional parental authority, but not other children. So the government is making a conflicting statement. It says necessary for us to protect these children from these fit parents, but not other fit parents. Well, then the next question, legal question, is what is the basis for that classification? And the basis for that classification is, well, we, the state, don't like the marital choices they made. Okay, well, are the marital choices lawful in your state? Well, yeah, we permit it. And are the lawful choices constitutionally permitted? So divorce is a free speech right, believe it or not, speech and association, right? And it's the mirror image. The right to speak includes the right not to speak. So the right to associate in marriage includes the right not to associate in marriage. And that means not only choosing not to get married, it means choosing to get unmarried. Otherwise, you could say, well, I'm in a free association with my neighbor and I learn things about him I don't like. The government tells me I have to stay in that relationship. The government can't do that. And marriage is no different. If anything, marriage receives is supposed to receive a great deal more protection. Best interest is over-inclusive because judges are given broad discretion to limit any number of fundamental rights, including imposing prior restraints on speech and association in many states up until complete no contact orders. Texas Supreme Court has said multiple times that it's lawful for them to issue no contact orders. Well, that's an absolute prior restraint against all speech and association between a fit parent and the child. That is unquestionably a First Amendment right. And there's absolutely no necessity that's proven or could be proven that that's necessary to protect that child's best interest. And the number one reason for this is because the federal government's parental preference doctrine says that the government must presume that you're a fit parent, and it must presume that you act in the child's best interest by federal law. This was discussed in Troxel, but it predates Troxel. And what states like Texas will do is instead of applying the federal law to the federal due process question, they apply the state law to the federal due process question. And that, again, is a violation of federal and state jurisdiction of the courts. So there is no question but that best interest and every family code in this country is massively overbroad.
He says he just wishes he could fight back. The attorneys are bankrupting him. That's why it's important you learn this stuff so that you can exercise it. So they pretty much bankrupt everybody, Jay, even millionaires.
Who controls the bar?
Yeah.
The state Supreme Court.
Yeah.
All right. So those attorneys are state approved speakers, and they are the only speakers that are permitted to speak in protection of your constitutional rights against the state.
And yet the
Bar Association, that's entire setup is unconstitutional. And when they challenged us a lot of years ago in Texas, the Unauthorized Practice of Law Committee sent us a nasty letter. We went straight to federal court, filed suit, said your statute's unconstitutional, your authority's unconstitutional, and won $1 million.
David must
They freaked out and backpedaled as quickly as they could because before it was dismissed on technical grounds, but the court said they have met their burden of proving that they are likely to proceed. So if you continue to
likely to succeed.
Yeah. So if you continue to screw with them, they will be able to sue. And the first thing that will happen is an injunction against your unauthorized practice of law because they've met the burden to get that preliminary injunction. They haven't said a word to us since then. That was years and years ago. And we continue. I continue to give legal advice in Texas.
David,
I want them to come after me.
So David, you're correct. He said, Jay, maybe taking your case to be reviewed by a civil rights lawyer could help. We won't get into too much detail with this, you guys, that will never get through this case, but you're welcome to send an email to, I'll put it in the chat here, custserve@fixedfamilycourts.com.
Go to our website and do the contact form.
Yeah, go to fixedfamilycourts.com and there's a contact form there and it will email us. And Jay says, in my case, the third DCA went against precedent and state statutes. In my case, I took it to the Supreme Court of Florida. Oh, gosh. And then they used discretionary jurisdiction to ignore your case. Did they?
There's no such thing as discretionary jurisdiction.
Okay. So, Jay, go to the website and email us.
It's whether the U.S. believes that it could cites at issue. But let me ask you one last question and fundamental question. Assuming that content neutral data collection concerns were is one of Congress's provisions, divest because of this. Why can't we separate that out from how we analyze the algorithm question? And couldn't we sever the two provisions to say divestiture is right, but you can't force them not to discuss algorithm?
Well, I think the reason why you can't do that was Mr. Francisco explained. I thought I'd direct you to a case like Hunter against Underwood and just analogize it to this situation. If what you had is the government saying, we are shutting down TikTok or requiring divestiture for two reasons. One, because we think it helps the Democratic Party too much. And number two, because we're concerned about data. I think that first interest would be a poison pill. That would be an impermissible, or because we think there's too much pro-Catholic content on TikTok. I think there are some interests that are just so constitutionally verboten that I think that just makes the act unconstitutional, and you can't go looking for other interests. You send it back to Congress. Look, if you want to pass a data security law free and clear of this impermissible interest, you go ahead and do it.
Well, that violates
Can I say one other
Taylor.
thing, Justice Sotomayor, just because I think it is also telling here that even if you didn't buy that poison pill argument and you just asked whether Congress would have passed this law, something else that I think you might notice is even if all this act goes into effect and the law goes through, TikTok gets to keep all the data. So wouldn't the data security law require them to expunge that data or get rid of it or something? I mean, it's a very weird law if you're just looking at it through a data security lens.
That's
Maybe
not
Congress
true
could
at
do better.
all, because they're constantly collecting more data and new data, even on existing people that are members of the site. So that is a straw man argument. It's more difficult for them to force them to give up all the data. And it's technically, in the digital world, impossible to force them to give up the data, because you don't know that they've got copies of it. You can't prove they have copies of it. There's no definitive copy. It's that's an impossibility.
And China doesn't have to follow our,
Yeah, well, if it's already in China, if it's sent over a telephone wire and got to China, an internet cable, there's no, you can't take it away from them. It's done. It's a done deal. It's over. The milk's spilled.
Yeah. So yeah, a lot of the government's arguments, they should focus heavier on the espionage. They're trying to get to that point, but they're failing when they keep bringing up data stuff, right?
Well, I think more likely they have some type of political interest from what's the Secretary of State? What's the agency she oversees? The
Health and Human Services.
No. Secretary of State. The negotiation.
Secretary of State.
Yeah. So we have public policy concerns. Our ultimate goal in China is to get them so economically dependent on the rest of the world that their dictatorial political regime crumbles and they have some semblance of a politically free country.
So their ultimate goal is to come in and disrupt here, and that's what it's very hard for government like this on this kind of scale to come in and put restrictions, because we are so cautious with our government. We don't want that opening the door to them just starting to do it, to, like, you start to let them interfere with our right without proving and applying all of the constitutional standards and requirements, then they'll start taking other rights, right? And so that's why it's such a battle, and you see this being fought over.
Yeah, the State Department is likely weighing in and saying, please don't make those arguments, because it defeats or that hampers our long-term higher order strategic goal of destroying the communist regime.
Right.
And it's no longer a communist regime.
But at the same time, we're keeping an eye out for our own rights, right? So a lot of this, the reason you have some of the users involved in there is because money is speech, and it is protected as speech as well. And so they're saying, hey, I'm on this app, I'm making money, I'm making a living, I quit my corporate job. So there's a lot of people, and then there's others whose dreams came true that they never would have been able to do anywhere else. So they're protecting their ability to succeed in America on a platform they chose, right? And so a lot of Americans need convincing if the government's going to take that away, right? And it's hard to convince them when you redact so much, because if you don't, then it gets to China, right? So it gets to other enemies. So all of this is very difficult. Like, even when I read the briefs, it was difficult because we don't get the critical information. So we're only hearing the perimeters of things, and so we're making judgments on that, whereas these justices, they're getting the unredacted stuff.
So one thing that TikTok does more than any of the other platforms I can see is, and I don't want to pick on a stereotype, but it's the only example I have off the top of my head, there are people out there that live in a right now immediate social world, and nothing else matters to them but friends and social standing and social interactions, and he said, she said, blah, 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 right? There are people, a lot of people in the world where that's 90% of their life. And those people have very few opportunities to make money doing that, at least legitimately, elsewhere. TikTok provides an avenue for them to monetize that desire to engage in that type of value discussion.
I mean,
no matter how much you may like it or not like it, it's a value discussion. And this is a venue, one of the few venues where they can monetize that.
And look, the majority of the people that are in this room and came in this room came from my TikTok.
Where she does a lot of that.
I made real connections, real interactions with people I otherwise would not have met, would not have made those connections with. But a lot of reason our family court connections aren't in here is they probably don't understand the connection between the TikTok and the family court. They're probably like, why the heck did you post that on our family court page, right? So yeah,
they tend to be heavily in pain, deeply in pain, and I tend to be a very serious-minded, goal-oriented person. So I can't. And I'm not trying to put anybody down, but I can't find any ability to engage at that level. So when Sherry's doing stuff she does on TikTok, I have to go. I have to have my office in a separate building because it just conflicts with our personality.
Yeah,
it's probably my fault, not hers. But I'm probably the fuddy-duddy, but that's just the way it is.
Yeah, Jay says, I understand, David, but the system is wild, wild west. There is no rhyme or reason for their decision. Exactly, Jay. That's why it's important to learn these foundational constitutional principles, because the only way, you guys, that we can get any kind of predictability out of our system is by all of us learning and applying these things and being able to fight for our rights. Like Tony said up here, he's like, fight for every right. Don't let them take a single right, because you let them take one, they start to chip away at the others, and they start to say you conceded them. So, Jay, just because they're not making any sense, just because they're violating your rights and getting away with it, does not mean that you lay down and that you don't take a stand and that you don't learn these rights to fight back with. So people have gone to jail fighting back. We have a father that Ron helped get out of jail. It took him like a year, but he helped him get out of jail.
He was in jail for 6 years total. I came in the 5th year, 4th and a half and 5th year, and fought like crazy and got him out.
Yeah, so
against
people go to jail
corruption
today, like Organic was saying earlier, for their rights. Okay, so that's why we find this important to listen to it. I know it's long, you guys. I know it's overwhelming when you're going through stressful things. It's even harder, and that's why it's good to have a friend like Jay. Look at David over here. He's saying, look, you've got people that understand. While they may not be able to personally fix it for you, he says there are people working on fixing things. Okay. So David, I just wanted to make a quick comment before Ron makes his, and then we start it again. Yes, David, people are working on fixing it. The issue that I have found is that it's usually the wrong fixes. And that sometimes just makes things worse, but it's a part of the process, right? It's a part of the process, and it makes it take a little longer because the government loves when you concede, and people going in and leaving best interest in place the way it is just to accept like a 50-50 parenting bill that they can just undermine using best interest as just a way to take away that energy and that momentum in that mission to fix the system. But the majority of people don't understand how to fix the system, and that's why Ron's always busy, you guys. He is always busy writing case law, working on cases with people, not writing case law, writing arguments to help them make those positions stronger, to help them fix it in the proper way.
So the problem is that the judges control the entirety of politically enforcing and judicially reviewing family law. And they are as corrupt as they can be, and that's at least $10 billion a year annually involved in this. There's massive amounts of money. Just think in your own case how much lawyers are paid, guardians ad litem, counselors, all these people that the court, one single judge controls how all these people get paid. Massive amounts of money, massive amounts of government power these judges have. They are corrupt to the core. They know, the ones that are qualified for their jobs know with no question that they're acting illegally, and the others are simply incompetent to be in their jobs. And the other problem with it, and they are doing everything in their power to prevent exactly the kind of discussion we're listening to here in the Supreme Court. The reason it continues is because they will not allow this kind of legal analysis, this legal challenge, even though that's their primary job, even at the trial court level. And so we're doing everything we can to force it into an honest court. The problem is a significant number of federal judges were previously state court judges, and they align to apply judicial immunity to prevent you from even challenging the statute.
Yeah.
In California, in the Ninth Circuit, the only person you can sue and challenge to the statute in the state is the judge, because that's the only one that has anything to do with enforcing it. And they won't permit you to sue the judge, even to challenge the statute at all.
We don't want them to feel like
Okay.
remorse. So, Jay,
Well, we have ways
even-
to fix that, but
yeah,
we're fighting
but
it.
even when it seems impossible, okay, even when it seems impossible, you don't stop fighting for your rights.
Right next door, the
Mhm.
10th Circuit, we have an active federal case, and they allow us to sue judges. And we're also suing Title
Thank you to
4D.
the rest of you who aren't in here for family law. We appreciate you staying, because this is important to everyone. And if they're interfering with somebody's rights in family law, all of you guys should care as well. At some point in time, it is going to affect you.
Right. The same judicial rules
whether it be
apply.
in a traffic ticket or your kids ending up in family court, whatever it is, you're going to want to know this.
Any trust reasons, for example. And as I take it, your argument here, and we don't think of those as normally implicating the First Amendment interests of users or people who might speak or associate with editors. And the difference here is, as I understand it, in your mind, that this law is motivated by a content-based interest. Is that a fair summary?
I think that, and the only thing I would add to it is just the prior step, which it is regulating the speech itself for content-based reasons.
Yeah,
Yes.
and we don't do that in the.
So I just wanted to mention something with that for Jay and David. Everything the family courts do is content-based. Everything they do, because it's based on them judging your parenting decisions that are lawful, and it's based on speech.
And in a few minutes, they're going to talk about person-based restrictions, right? Speaker-based restrictions. And they will say that all speaker-based restrictions are content-based, because you can't divorce content from the speaker, because every speaker's is unique in the content they're expressing. And best interest, the entire purpose of best interest is to apply a speaker-based valuation to provide more speech and association to one parent, less speech and association to the other parent, which is censorship, which is content-based censorship.
Antitrust area, but
Exactly.
you say this law does. Okay.
Exactly.
And it does on the covert content manipulation side. Do you think that's a compelling interest or not? Forget about the tailoring for a moment.
No, my point is that preventing content manipulation, whether it's covert or not,
Is simply
is
not
impermissible. If what you mean by content manipulation are the kinds of interests the government is saying, like undermining trust in our leaders,
And that's
undermining trust in
Whitney and
democracy.
Abrams in your-
That's Whitney and Abrams, and like those
Got it.
cases.
I got it.
Yeah.
I got it.
So,
Just a couple more. I'm sorry. I'll finish up real quick. And so that would take us to the tailoring question. And there you say disclosure and alerting Americans that there is covert content manipulation possibility, putting aside the data collection part of it.
Yeah.
Telling Americans that there is covert content manipulation going on in TikTok, or at least it's possible. And the government says that's just simply not enough. And the DC Circuit did too. And I wanted to give you a chance to respond to that.
Right. So I think that's the only aspect of the governmental interest that could be permissible, the covert part. And my answer, as you just said, is disclosure solves that problem. And you have a longstanding law, which we haven't talked about yet today, that gives you that example. Again, under a history and tradition test, you look at not just precedent, but laws and our traditions of our country. Look at the Foreign Agent Registration Act, passed in the run-up to World War II. And the concern was Americans would be controlled by foreign agents to speak and advocate certain causes.
We didn't ban them.
We did not ban them. All you did is Congress, all Congress did was require a disclosure.
Certainly wasn't. I wasn't around for that. On the secret evidence point, I'm concerned about the government's attempt to lodge secret evidence in this case without providing any mechanism for opposing counsel to review it. And I expressed that concern in Zebeda, and I noted that there are mechanisms to read in counsel and that other countries, including our allies, often do that. I just wanted to give you a chance to give me your thoughts on that.
Yes, Justice Gorsuch, we made all those arguments in the DC Circuit, so there was a flurry of motion practice about whether or not the government could rely on classified evidence. Those motions were never resolved. What the DC Circuit did, I think you probably noticed from the decision, is say we're going to decide this case solely based on the public record. And my understanding is that's how it comes to this court.
It's
But if
interesting
the court were ever
It's interesting that Congress hasn't acted in this field. I mean, we have in the FISA area, lots of opportunity. They have regulated this area, and it does seem like an area that Congress might want to pay attention to, given the increased appeals to secret evidence that the government has made in recent years. Last question for you. Could the new administration after January 20th, Mr. Francisco suggested that it might be able to extend the deadline, even though if you were to lose here by January 19th, is that possible as you read the law?
I'm not sure it is. I'm not sure. Maybe that's a question for the Solicitor General. But
it certainly is. I thought maybe I'd give you a chance too.
So, as I understand the law, it's 270 days unless extended. And once that time runs, I'm not sure you're talking about an extension anymore.
Okay.
There's ex post facto law that kind of does this stuff.
Thank you.
Can I take you back, Mr. Fisher? Let's say I agree with you that if you're talking about content manipulation, that's an inherently content-based rationale for acting. So if Congress had passed a law that says we hate the content manipulation that TikTok is doing, that's strict scrutiny land, and I don't know that the government can do that, however important and the interest. But that's not what Congress is doing here, and this is the same kinds of questions that I asked Mr. Francisco, because if let's take it as a given that Congress actually can do whatever it wants with respect to a wholly foreign corporation or a foreign government, and so Congress could act with the intent to interfere with the content manipulation that a foreign corporation is doing.
Yeah, but I have a question. They say they can do whatever they want. You've got 170 million Americans, a lot of them making their living on there. That doesn't make them too happy.
Okay, but the reason they can do what they want, particularly the president, in terms of engaging with foreign governments, is that there are enumerated powers written into the Constitution that give the president this authority. So those enumerated things written in the Constitution are written in the same document. The protections are written.
I was responding from an emotional perspective that we would be upset about it, because what if I know this is gonna sound ridiculous, you guys, but what if they're just wanting to get rid of it because he's gonna send all these immigrants back and they have no labor for their companies, so they're hoping all these TikTokers are out of job and they have to go sift their worms for them.
Well, he has a staggering degree of direct constitutional authority to do those things.
Well, I understand, but I'm saying maybe they're like, hey, there's 170 million Americans on there. We need them back in the workforce.
And the court will not, in most cases, will not second guess the exercise of that authority because it's specifically given to
I don't think you're helping the matter.
No, I'm not helping your emotional thing. I hate it 90% of what the government does. So it's pointless to hate what the government does.
Still farm freedom.
And so now we're in this strange world where we're saying they can't act with respect to TikTok. They could act with respect to ByteDance. Why isn't this Congress acting with respect to ByteDance, in the sense that all it's doing is saying ByteDance has to divest, and then TikTok can go about its business, use whatever algorithm it wants, use whatever content moderation policies it wants, just like everybody else does, choosing from everything that's available on the open market.
So let me answer that question in two parts from the perspective of the creator Americans who want to use this platform to speak to other Americans. So the first thing is what the act does, as you said, Justice Kagan, is prevent us from working with a application that is owned by ByteDance that uses this algorithm. Well, that's exactly what we want to do. That's our editor and publisher of choice that we think best disseminates our speech.
Yeah, but what I'm saying to you is, if you just assume a world without TikTok, where it's only ByteDance, and you were trying to say, well, we really want to work with ByteDance, and Congress was saying, we think ByteDance presents national security interests, and they don't have First Amendment rights. They're just a foreign corporation. I think that in that case, the government, tell me if you think this is wrong. It just doesn't matter that you have creators who want to work with ByteDance, because ByteDance is a foreign corporation with no First Amendment rights. Is that what you're contesting?
So that is what I'm contesting. So you said two things, though, so I could be clear. There's two aspects. Do we have a First Amendment right to work with a foreign company or even a foreign country to publish our speech? And then there's a national security part that you put into that, which goes to the justification.
Forget that.
But forget that. Yes, let's do that. So if that is right, Justice Kagan, then American creators have no right to make documentaries with the BBC. They can't They can't work with
Used to work in the
Al
Trump
Jazeera
administration.
if Congress wants to prevent that. Any number of other publications that are state-owned wholly or partially. And even under Lamont, remember, where you're not even creating speech, you're just listening. That was speech from China. That the court said you have a First Amendment right
So
to
would I
receive.
be right to say that your position is that because of the users who want to associate and want to partner with this foreign corporation, the foreign corporation ends up having, in your view, the exact same First Amendment rights as your users do? In other words, it's
That's wrong.
irrelevant that the
He may
foreign
say that,
corporation
but it's
doesn't
wrong.
have First Amendment rights.
I don't think it's irrelevant, because you could imagine a situation where no American distributor or speaker wants to work with that. But let me put it to you this way. The Communist Manifesto, written by Karl Marx, has no First Amendment standing on its own in America. But if a bookstore wants to sell that publication, I don't think Congress can prevent it from doing so.
Well, oh, sorry. Go ahead.
No, I'm fine.
No.
I'm good.
Okay. So I want to press you a little bit on the distinction, because in Lamont, the prohibition worked directly on the American. Like, you have to specifically request this information that comes. This is working kind of as Justice Kagan's questions were pressing you. This is working on ByteDance. It's not saying to your creators, you can't post on ByteDance. That's indirectly going to happen if ByteDance chooses itself not to permit TikTok to walk away with the code. So does that matter, that distinction between Lamont and this case?
No, for two reasons. One, under the Sorrell case, you look to not just the law itself, but its practical operation. And the practical operation is prevent us from working with ByteDance. So that's one answer. And you bring up Lamont, and Lamont too.
So I want to comment on what he said in that exchange right there, right? Because she started this off by saying, well, they can just go out and get whatever algorithm. She's presuming that there is a market of algorithms and you can go out and buy an algorithm. That's a false presumption, because these algorithms are the central core element of those companies' business models. There is not a free market in these algorithms that can produce a TikTok. If there were, there would be dozens of them, and there aren't. Right? So that algorithm is a key competitive advantage for each of these platforms. That's a vital issue that has to be addressed in there. So her premise is completely and utterly wrong on that. And that's common when you deal with Supreme Court justices in technology, because most of them just live in a non-technology world, and they're older, most of them, and then they didn't grow up with technology. Like me, I didn't grow up with any technology. I grew up in the 70s. We didn't have that stuff. I remember transistor radio being a big deal.
Working on ByteDance. It's not saying to your creators, you can't post on ByteDance. That's indirectly going to happen if ByteDance chooses itself not to permit TikTok to walk away with the code. So does that matter, that distinction between Lamont and this case?
No, for two reasons. One, under the Sorrell case, you look to not just the law itself, but its practical operation. And the practical operation is prevent us from working with ByteDance. So that's one answer. And you bring up Lamont, and Lamont's actually a very important case, I'm sure you all recognize here. It's important to look not just at the court's opinion, but look at the briefing in that case. The government itself never came in and argued there's no right to receive this information. That's the sort of greater argument. All the government argued was, of course, Americans have a right to receive this, but it's just not so much of a burden to require them to raise their hand to get it. So Archibald Cox, when he was the Solicitor General, said to the court quite explicitly in the brief, we're not even going to make this argument because we think it's so contrary to history and tradition. All we're going to argue is the burden isn't enough. Now, what happened is the DC Circuit kind of turned that upside down and said, oh, Lamont's just a case about the burden. Well, that's because that's the only argument the government was even willing to make in this court. There was no argument that Americans didn't have the right to hear that speech.
What about, so I think this goes to Justice Gorsuch's questions about antitrust divestiture. Let's say that for antitrust reasons, or let's even say not for that. Let's say for suspect First Amendment reasons, Congress tells Jeff Bezos that he has to divest in the Washington Post. He can no longer own the Post. And let's say that neither Bezos nor the Post challenges that. But let's say that you represent clients who really like the Post as it was, who really want to keep receiving the Post, who really want to publish op-eds in the Post.
Yep.
would you have standing? Like, what kind of a claim would you be making there?
I believe so, Justice Barrett, and the court has cited Lamont and other cases in more recent years to say we've recognized a right of American listeners to receive information from others. And remember, even that is a lot. That's only a small part of the argument I'm making on behalf of the creators. I don't mean to diminish Mr. Francisco's arguments on behalf of the company and ByteDance, but the core speech in front of you in this case are the videos and other forms of communication that people like my clients are posting by the millions every day on this platform to share with other Americans.
Can you win is it possible for you to win and Mr. Francisco to lose, or you rise or fall together?
No, I think it's possible. I mean, I don't think we should. But
was it possible for you to win and him to lose?
Well, let me put it this way. If you were to conclude that something about the corporate ownership structure, and I think there was some conversation about this earlier, impeded Mr. Francisco from being able to assert full-throated First Amendment rights in this case, I would step in and say, well, certainly we can do that and get you to the strict scrutiny. And then the arguments pretty much line up. Then you're in a question of, can the government satisfy strict scrutiny? And I think, Mr. Chief Justice, you asked about, do we have cases for this and that? I think that the idea is, yes, we have cases that say, once you're in strict scrutiny, that regulating the content because you don't think it's going to be pro-American enough or it's going to be too pro-foreign interest is just verboten under the First Amendment. That's the history and tradition. And Justice Kavanaugh, when you asked about the broadcast cases, they're grounded not just in scarcity, but they're grounded in scarcity in a particular way. It has to do with the absolute need Congress has for licensing in a world of scarce resources. And so that's the very small carve out that even in Turner, the court wouldn't extend to cable television, that it exists for broadcast licensing. And if you look on the 200 plus years of our country for any other example of foreign ownership of media being regulated by Congress, let alone being permitted in the case law, you are not going to find it. And I think the reason why is because everybody has understood that if you're not in a world of scarcity where licensing is impossible, you cannot give the government, and in this more extreme example, the president himself, unbridled discretion to choose who is a proper owner of a speech platform in this country, because it is so hand in hand with viewpoint. As I said earlier, any number of owners of big media enterprises, whether they be Americans or foreign citizens, could be accused of having a particular viewpoint, but speakers who engage in those platforms have choices they can make. And so, on behalf of our creator clients, we find it not at all satisfactory to be told, well, look, just go post somewhere else. It's not enough to tell a writer, well, you can't publish an op-ed in the Wall Street Journal because you can publish it in the New York Times instead. Just like here to say, you can publish it on Instagram or some other platform, not just TikTok. TikTok has a distinct editorial and publicational perspective, and it particularly benefits people like my clients who are not famous people. They're not actors from Hollywood who have a lot of people following them. They're ordinary American citizens whose content that they create on the platform gets privileged by way of the quality of that content. And that's what's so powerful about the platform. So whether you're an ordinary American citizen or, I might add, whether you're a presidential candidate in our last election, if you want to reach new and different audiences, TikTok is the place people go.
This may not make any difference for constitutional purposes, but just out of curiosity, I'd like you to explain what the practical consequences would likely be for your clients if TikTok went dark, as Mr. Francisco put it. There, I assume, is a great demand for what TikTok provides. And if TikTok was no longer there to provide what your clients really want, is there a reason to doubt that some other social media company would not jump in and take advantage of this very lucrative market?
There are two reasons, Justice Alito. One is many of the declarations from my clients actually explain they've tried on other platforms to generate the kind of audience and engagement they've been able to on TikTok, and they've fallen dramatically.
Yeah, I know they haven't so far, and I'm just wondering whether this is like somebody's attachment to an old article of clothing. I mean, I really love this old shirt because I've been wearing this old shirt, but I could go out and buy something.
He has
exactly
particular
like
biases
that,
that
but
can be
I like
strong,
the
but
old
he's
shirt.
otherwise
Is that what
strong
we
on
have
the
here, or
First
is there
Amendment.
some reason to think that only ByteDance has this the ByteDance has devised this magical algorithm that all of the geniuses at Meta and all
Yes,
of these
they
other
have.
social media companies, they couldn't. No matter,
Well,
they put their
that
minds
plus
to
the
it, they
marketing
couldn't
plus
come up with
positioning
this
and all
magical
kind of
thing.
whole
I
things
think
coming
empirically,
together.
other companies have been trying for a few years to catch up with TikTok and replicate it and have been very unsuccessful. So
Yeah.
that ought to tell you something. And so just imagine the algorithm here as a collection of thousands of editors. Imagine the floors of an office building being filled with a collection of editors. You could imagine a situation where that collection of genius that is on a particular floor cannot be replicated by another group of people. And that's
all
kind of
I
what
say
you
it's
have
not
here.
like other companies aren't
Thank
trying.
you, counsel.
They haven't
Justice
succeeded
Thomas.
yet.
Anything further, Justice Alito?
But yeah, one other question. I'm intrigued by your Mount Healthy Hunter versus Underwood argument. I mean, maybe you're right, but Mount Healthy arose in an entirely different context where you're trying to get to an employer's motivation. Hunter versus Underwood involved an extreme situation where the court looked at the records of a state constitutional convention and came to the conclusion apparently that racism was the only motivation for what was done. But it does seem to me to be potentially quite unworkable and contrary to what we've generally said about legislative intent to apply the Mount Healthy framework to a congressional enactment. Do you recognize or do you acknowledge that that would be very difficult? Because when an act of Congress is passed, there could be more than 250 different motivations for the votes that were cast by the members.
Yeah, I totally understand that. And in Hunter, the court actually engaged with that problem to some degree. And what Hunter said is to avoid that problem, we're going to look just at two things. One is the state's brief, which I'd say is the Solicitor General's brief by comparison here, and the text of the law. And here, that's the only thing I need to rely on to get you to the place that they wouldn't have announced.
Well, it gets you to the place that this was part of what motivated Congress. But why does it get you home?
Well,
and particularly when there's a severability clause in this act.
It can't be only part of it. It has to be enough to sustain the entire act, or at least the parts that you wouldn't sever from the act. And so I think the reason why is because it's not just the content recommendation algorithm part that can be theoretically, I guess, severed out. It's also the covered company provisions, and it's just the whole approach of the statute that is based on content, not on data security.
All right, thank you.
So, okay.
Justice Sotomayor?
Save it for the SG.
Justice Kagan? Justice Gorsuch? Justice Kaplan? Justice Jackson?
One quick question. You repeatedly say that from your perspective, the government's motivation is that the content might be too anti-American or too pro-China, et cetera. So that's why you think this is a content-based restriction. But I guess I'm curious if you would say the same thing if the government had articulated its rationale as saying, our motivation is to limit foreign interference in American social media platforms or discourse. Isn't that a different motivation from the standpoint of how we characterize this?
I agree, but then the question I would ask if the government said that, which I think kind of in the reply brief, maybe the government does say that, is that how on earth are you then serving a national security interest? If all you're doing is just saying, we don't like a foreign country rearranging cat and dance videos, it's hard to come in and make a national security argument. So the only way you get to national security, which is the government's own argument, is to look at the substance that's being rearranged and say, we don't like the way the substance is going to be rearranged and curated differently.
Thank you.
Thank you, counsel. General Prelogar.
Mr. Chief Justice, and may it please the court.
This is
The
Solicitor
Chinese
General for the
government's
U.S.
control of TikTok poses a grave threat to national security. No one disputes that the PRC seeks to undermine U.S. interests by amassing vast quantities of sensitive data about Americans and by engaging in covert influence operations. And no one disputes that the PRC pursues those goals by compelling companies like ByteDance to secretly turn over data and carry out PRC directives. Those realities mean that the Chinese government could weaponize TikTok at any time to harm the United States. TikTok collects unprecedented amounts of personal data. And as Justice Sotomayor noted, it's not just about the 170 million American users, but also about their non-user contacts who might not even be engaging with the platform. That data would be incredibly valuable to the PRC. For years, the Chinese government has sought to build detailed profiles about Americans, where we live and work, who our friends and coworkers are,
what our interests are, and what our vices are. TikTok's immense data set would give the PRC a powerful tool for harassment.
Wait. That's kind of already out there on Facebook, Instagram. Like people
But
willingly put
Facebook
that
and
up there.
Instagram are not sovereign states who are quasi
I'm just
adversaries
saying they
with
can
us.
see it all already.
No, they can't. They can't access your private data. Then you can't go and look at someone's Facebook and see all their private data if they didn't share it. But the company has every bit of it, what you shared and what you didn't share.
Recruitment and espionage. On top of that, the Chinese government's control over TikTok gives it a potent weapon for covert influence operations. And my friends are wrong to suggest that Congress was seeking to suppress specific types of content or specific types of viewpoints. Instead, the national security harm arises from the very fact of a foreign adversary's capacity to secretly manipulate the platform to advance its geopolitical goals in whatever form that kind of covert operation might take. The Act addresses the threat of foreign adversary control with laser-like focus. It requires only divestiture of TikTok to prevent Chinese government control. And that divestiture remedy follows a long tradition of barring foreign control of U.S. communications channels and other critical infrastructure. So no matter what level of First Amendment scrutiny applies, this act is valid because it's narrowly tailored to address compelling national security threats. Now, my friend Mr. Fisher just emphasized, and I acknowledge, that millions of Americans enjoy expressing themselves on this platform. But the important thing to recognize is that the act leaves all of that speech unrestricted once TikTok is freed from foreign adversary control. The First Amendment does not bar Congress from taking that critical and targeted step to protect our nation's security. I welcome the court's questions.
Is there any difference between content manipulation by a non-U.S. company as opposed to a U.S. company? I didn't hear Mr. Fisher make a distinction between the two.
Yes, and I think the important thing to recognize is that the act here is targeting covert content manipulation by a foreign adversary nation. Now, I understand my friends to say—
What difference does that make?
The difference is that there is no protected First Amendment right for a foreign adversary to exploit its control over a speech platform.
The difference between covert and non-covert.
So I think that Congress's concern with the covert operation was that a foreign adversary could effectively weaponize this platform behind the scenes in order to achieve any number of geopolitical goals. Here are some of the examples that come to mind. One of the pages out of the playbook here is for a foreign adversary to simply try to get Americans arguing with one another to create chaos and distraction in order to weaken the United States as a general matter and distract from any activities that the foreign adversary might want to conduct on the world stage.
By covert, though? I mean, does covert just mean it's hard to figure out how the algorithm works? Because we could say that about every algorithm.
No, the covert nature of it comes from the fact that it's not apparent that the PRC is the one behind the scenes pulling the strings here and deciding exactly what content is going to be made to appear on the site. And another way that
it's just because we don't know that China's behind it. That's what covert means.
Well, I think
it doesn't have anything to do with the difficulty of figuring out what the algorithm is doing. It's just because people don't know that China is pulling the strings. That's what covert means.
What it means is that Americans are on this platform thinking that they are speaking to one another, and this recommendation engine that is apparently so valuable is organically directing their speech to each other. And what is covert is that the PRC, a foreign adversary nation, is instead exploiting a vulnerability in the system.
Well, if that's all it means, that like people don't know that China's behind it, like everybody now knows that China is behind it.
No, but it's the specific content that's being manipulated would be unapparent. And so
I think that's true of every search engine. I mean, you can take any of these algorithms, whether it's X or whether it's, you name it. What are the new ones? Blue Sky. I mean, none of these are apparent, right? You get what you get and you think that's puzzling. And it's all a little bit of a black box. So you can't just mean it's a black box, it's covert. They're all black boxes. And if you just mean what's covert is the fact that there's China behind it, I mean, honestly, really, like everybody does know now that there's China behind it. So I just don't get what this covert word does for you.
I think the problem with just saying as a general matter, China has this capability and might at some point be able to exercise it and manipulate the platform is it doesn't put anyone on notice of when that influence operation is actually happening. And therefore it doesn't guard against the national security harm from the operation itself.
Isn't that a pretty paternalistic point of view? I mean, don't we normally assume that the best remedy for problematic speech is counter speech? And
it's the foreign adversary.
TikTok says it could even live with a disclaimer on its website saying this can be covertly manipulated by China. In case anybody were left in doubt after today about that possibility. So you're saying that won't work because
that won't work because it is such a generic, generalized disclosure that it wouldn't put anyone reasonably on notice about when it's actually happening. And the example I've been thinking about is
argument is that the average American won't be able to figure out that the cat feed he's getting on TikTok could be manipulated, even though there's a disclosure saying it could be manipulated.
But imagine if you walked into a store and it had a sign that said 1 of 1 million products in this store causes cancer. That is not going to put you on notice about what product is actually jeopardizing your health. And I think that's roughly equivalent to the type of disclosure they're contemplating here.
This is relevant in family law
Foreign
because
Agents Registration Act
judicial pleadings, judicial pleadings do not establish the degree of constitutional notice necessary for the state to regulate your private life, right? The pleadings just aren't designed to meet that standard. In the beginning, I thought they were, and that at first it seemed that way. But the more I've learned about it, the more I realize they've moved to a liberal pleading standard, means that all the pleadings have to do is basically put the other side on notice of the basic nature of the case to establish that they're standing in subject matter jurisdiction, which they don't even have that in family law, and that you move forward, and the rest of that is proven throughout the proceedings. So you don't have to put everything in the pleading that you ultimately get relief on. Now that's contrary to the notion that the Constitution mandates notice of regulation of your fundamental rights. That notice is very specific, like she's getting here. These justices know this. They apply this all the time. And so they're playing a little devil's advocate here in the speech, but I know they know better.
That's the actual content.
If that's true, then wouldn't that be true for all social media companies, for all content? I mean, every editor, every newspaper in its editorial room makes decisions about what it's going to run and how it's going to say it. And every algorithm has preferences, whether it's domestic or foreign. And nobody really knows exactly when those editorial decisions are being made or how, but they're generally aware. We think that's enough.
I think, though, that there is a real risk that when a foreign adversary has control of that kind of mechanism and a speech platform in the United States, it could weaponize that platform to harm United States interests. And one of the key ways that the PRC flexes this muscle is to suppress speech.
General, I'm sorry to interrupt you, but I'm not arguing about the compelling interest. We're arguing about the tailoring.
Right. And so I guess what I would say, you began by saying the cure for concerning speech is counter speech. Here, I dispute the premise that Congress was specifically concerned about any particular subject or any particular viewpoint. It wanted to close off the capability of a foreign government. But in any event, it's very hard to engage in counter speech when you don't know because someone is secretly manipulating the platform behind the scenes. And in particular, what the PRC has the capability to do is simply silence American voices.
Newspaper owned by a foreign company and a foreign government, you wouldn't know when it's exercising editorial discretion about this article or
that kind
that
of data
article
about their people,
or how it's doing it. So maybe we just need to shut down the Oxford University Press in America.
The newspaper doesn't collect detailed data about you and your connections and your contact list and all those things. That's apples and oranges comparison.
So that would all be okay on your theory so long as Congress designates that country a foreign adversary?
We are not asking the court to articulate bright line rules to govern all kinds
I
of
understand that,
hypothetical
but
situations.
I am testing your argument.
Yes, and what I want to acknowledge is that sometimes the court has recognized that a speaker-based preference might reflect a content-based preference. And in the context of ownership of a newspaper, for example, in part because a newspaper is a one-way channel of communication and is generally understood to represent to some extent its publisher's views, maybe the court would more readily infer that a regulation targeting that is actually aiming to target content. But I don't think the court could draw the same
I'm not talking
conclusion
about
here.
the compelling interest or anything. I'm
Right.
talking about the tailoring. And you're saying we have no alternative but to stop this speech altogether. We can't rely on disclosure.
But
you say
PRC
that
is
wouldn't
not
apply to
entitled to narrow
Politico or
tailoring.
to the Oxford University Press because
In the circumstance where you have a newspaper that is understood to reflect its publisher's views, then you might think that disclosure would be a more adequate remedy there because it's not just holding itself out as a forum for speech between other people. I think social media platforms do raise distinct interests in this regard because what people think when they're engaging with TikTok is that it's organically feeding them videos based on the recommendation engine. And if actually China is behind the scenes engaging in this kind of covert operation, it does prevent a distinct national security risk. Of course, the other big difference with the newspaper is it's not likely to be collecting sensitive personal information about 170 million plus people and then having the capacity to send that back to a foreign adversary.
General
Counsel?
Prelogar, can I, oh, go ahead.
I was just going to say, did I understand you to say a few minutes ago that one problem that ByteDance might be through TikTok trying to get Americans to argue with each other?
That it might be just trying to
If they
foment
do, I say they're winning.
disruption or dissent.
They are. You've
That
nailed
might
it.
very well be true, Mr. Chief Justice. And I think the point I'm trying to make is that China is
You
a foreign
sow
adversary
dissent in your
nation that
enemy.
looks
That's
for
a
every
classic
opportunity
Sun
it
Tzu
has to
tactic.
weaken the United States and to try to threaten our national security. And if it has control over this key communications channel, it's hard to predict ex ante exactly how it's going to use that as a tool to harm our interests. But we know it's going to try, first and foremost, by seeking to get the data of these American users, which would be of a piece of all of the activity that PRC has already undertaken to breach our laws, hack OPM, for example, and exfiltrate the background files and security clearances of 20 million government employees, the breach of Equifax to get sensitive financial data, Anthem to get sensitive healthcare data. We know that the PRC has a voracious appetite to get its hands on as much information about Americans as possible, and that creates a potent weapon here because the PRC could command that ByteDance comply with any request it gives to obtain that data that's in the hands of the U.S. subsidiary.
Thank you.
General Prelogar.
Suppose that TikTok had no connection whatsoever with any foreign government. It was owned instead by an immensely rich multinational corporation, and Congress concluded that this multinational corporation really has it in for the United States and is going to use this extremely popular platform to do everything it can to undermine the United States in all the ways in which you think that TikTok may pursue at the direction of the PRC. Would that be the same case?
I think there would be a first order question of whether the multinational corporation itself has First Amendment rights.
All right, it's an American corporation.
So if it were an American corporation, I think that and Congress disagreed with the viewpoints or content the corporation would display, obviously that's a direct regulation of protected speech and it would trigger strict scrutiny. I think that's different in kind from what Congress was worried about here, which was not regulating speech as such, but instead regulating foreign adversary control. And
So your argument depends on the fact that what is at bottom here is the People's Republic of China using TikTok. That's what your argument depends on. If this were an American corporation, it'd be an entirely different thing.
Exactly. And the reason we know the statute is different is because all of the same speech that's happening on TikTok could happen post-divestiture. The act doesn't regulate that at all. So it's not saying you can't have pro-China speech, you can't have anti-American speech. It's not regulating the algorithm. TikTok, if it were able to do so, could use precisely the same algorithm to display the same content by the same users. All the act is doing is trying to surgically remove the ability of a foreign adversary nation to get our data and to be able to exercise control over the platform.
I'm sorry.
I just wanted to respond to Mr. Fisher's argument about the rights of Americans to receive information, say, from the PRC or anyone else, and that even if ByteDance did not itself have First Amendment rights, that Americans would have a First Amendment right to receive that information in the Lamont sense.
Yes, so I think that Lamont reflected a principle that there can be a right of American listeners to receive information. And if Congress is directly regulating that based on disagreement with the speech that's being sent into this country, that's obviously going to trigger heightened scrutiny under the First Amendment. But here, I think the users have to be asserting a different type of interest, because what Congress was safeguarding against was not the ability of TikTok to continue to operate or the users to post content. It was focused only on foreign adversary control. And so the users would have to demonstrate that they have some unqualified First Amendment right to post on a platform that's controlled by a foreign adversary, which could use that access to then threaten our nation's security by gathering data on tens or hundreds of millions of Americans, and also use it for covert influence operations of whatever form. And I don't think there's a First Amendment right to do that.
I was trying to think of whether there's a historical analog here, and this is what I came up with, and you can tell me whether it's fallacious.
There is not.
In the mid 20th century, we were very concerned about the Soviet Union and what the Soviet Union was doing in this country. And the Communist Party of the United States at that time was integrally attached to the Communist International, which was essentially a Soviet operation, right? So if Congress had said, well, it's very nice, we can have the Communist Party USA, but it has to divest, it has to completely divorce itself from the Comintern and from any international ties that it has. Do you think that that would have been absolutely fine? And so if the answer is yes, it would have been fine. It's just like this case. Or if the answer is no, why is it not like this case?
So I guess I think I would need to know more information about how the international organization.
Okay. So I'm going to jump in right here because this is one of the parts that I heard earlier. So what they're talking about is there's a lot of case law on the books about Communist Party propaganda and the Communist Party existing in this country. One of the particular cases is NAACP versus Alabama, where an attorney was denied membership in the bar because he had previously been a member of the American Communist Party. And the Supreme Court said that his membership in the Communist Party could not be a justification for preventing him from joining the bar, right? Because his membership in an ideology was not an active, overt attempt to violently overthrow the government. He wasn't advocating violence against the government. And just because you belong to an organization doesn't mean you agree with its entire platform. I'm sure on the listening right now, there are lots of registered Republicans, registered Democrats, and I would be more than willing to bet that there are parts of your party platform that you're not 1,000% in favor of. Was the same way with the Communist Party, right? So they didn't have the means to show that he was in any way engaged in actively violently overthrowing the government, which they can prohibit. And because of that, mere membership in the organization and the association wouldn't work. But here, the Solicitor General, that's the person who argues Supreme Court cases for the United States government. And there are several of them. There's a chief solicitor and several of them because there's a big caseload. But she is arguing that there is exactly that type of active, ongoing attempt to violently overthrow the American government. And that is through active, covert technology manipulation, attacks on technology systems, data disruptions, using industrial control mechanisms to disrupt production and traffic flow and aircraft and electricity and water and sewer. All of that is controlled by computers. And getting access to that, and the easiest way to get access to that is to trick someone into giving it to you. It's called spoofing, right? And by having all this information about someone, it makes it 1,000 times easier to spoof people because you can say things that give them confidence that you're a good actor. And all the while you stole all that information, right? So there are real valid concerns here. And in the 1930s, the impact, the damage that Soviet propaganda could do here was minimal. I mean, the real impact of newspaper and communication technologies at the time was nothing. And they're not talking about propaganda impact here. They're talking about the ability to use data that clearly newspapers do not collect and propaganda organizations do not have access to generally, and to manipulate that data for all kinds of nefarious purposes, such as spoofing and other things that can do real damage, like shutting down your electricity in the middle of a devastating winter storm where you have no heat, right? That's life and death stuff. So the government's arguments here are real, they're substantial, they're narrow, and they are articulated in a way, finally, that gives me some belief that they might actually prevail in some degree on this.
Is able to exercise.
One other quick question. So the national security interest, there's a famous First Amendment case, New York Times versus, I think it's Sullivan, but there's several New York Times cases. There was a prior restraint issue, and a newspaper, New York Times, wanted to publish some data information they had received that was confidential and restricted by the federal government. But the government tried to restrict the New York Times from publishing this information, and they asserted national security interest. But they didn't assert the kind of narrowly focused and specifically targeted interest that the Solicitor General is articulating here. They articulated just vague things. They refused to be specific about the injury, probably because describing the injury would have caused the harm they wanted, or maybe they had no justification. Who knows? But the Supreme Court said that broad allegations of national security simply won't do to impose prior restraints. So I don't know if they're going to mention that case or not, but that's one of the cases that will be analyzed under this line of reasoning.
Control over the American affiliate. And if it had the capacity, for example, to, in an unqualified fashion, gather data from that affiliate in a way that was going to jeopardize our nation's security.
Well, I'm talking more about sort of the content. Let's put the data collection piece of this aside, which seems not very pertinent to my 1950s analog. But, very concerned about the kind of speech that the Communist Party was making in the United States. And it turns out that that content was pretty well scripted someplace else.
I think if it was specifically a concern about the content, then that would trigger heightened scrutiny under the First Amendment. We're not trying to run away from that principle here. Instead, we're making, I think, a narrower argument.
Well, then I think that you're I think you've just given your thing away, because content manipulation is a content-based rationale. We think that this foreign government is going to manipulate content in a way that will that concerns us and may very well affect our national security interests. Well, that's exactly what they thought about Communist Party speech in the 1950s.
So notice here that the justice is articulating this in very broad, non-specific terms. She's aligning with the ruling in New York Times, but that's not what the government's argument is. The government's argument is pretty specific, and anybody in technology, and particularly technology security, will tell you that the concerns are real, they're valid, they're ongoing, they're massive. We are currently under one of the most massive attacks ever. It's unprecedented, and it's directly coming from China. And so we are in it's like the Cold War with the Soviet Union, in that there are active battles ongoing, but no declared war. In the meantime, we're trading partners, so it's a lot more complicated. But that's a real Cold War situation with active battles ongoing through technology that are mostly covert, just like in Vietnam and Cambodia and all those strange little places over in the Far East that most of us know very little about. Those things are ongoing. Those things are real, and they have to be protected against. That doesn't mean we give the government carte blanche to go bombing Cambodia, but it does mean that the government has to have some ability to protect us from a clear foreign adversary that is openly a foreign adversary. At the same time, they're a trading partner, right? And we're trying to play the long game, which is China's strong suit, and getting them so economically connected to the rest of the world that they can no longer maintain the dictatorial control over their politics.
Which was being scripted in large part by international organizations or directly by the Soviet Union.
I disagree that the concern with covert content manipulation is itself content-based, or that it looks anything like the kinds of laws this court has previously said are content-based. The court most recently in City of Austin said you only have a content-based law when Congress is setting out to discriminate against particular subject matters or particular viewpoints. So it's not enough that the law is regulating in the space that involves content in some way. You have to have this motive by Congress to actually want to suppress speech on certain topics or certain viewpoints. Here, Congress just wants to cut the PRC out of the equation altogether, and all of the same speech could continue to happen on the platform. It's like patching up a backdoor vulnerability that the PRC has that we can't totally see around all the corners to imagine how it could use it against our interests, but we know the PRC will do whatever it can to try. And I think that is different in kind from imputing to Congress some motive to specifically get more speech on certain topics or with certain viewpoints. This law was passed by broad bipartisan majorities in both houses of Congress, and our legislators don't always agree on everything. I think it's unlikely that all of them had exactly the same views about what's good content on TikTok or what are good viewpoints. They weren't united on that. What they were united around was the idea that it is a grave threat to our nation if the PRC can itself behind the scenes be controlling how this platform operates.
Why doesn't this act classify on the basis of speaker?
I do think that when it comes to the PRC and ByteDance, you could treat this as a speaker-based restriction.
And aren't speaker-based restrictions almost always viewpoint-based restrictions, content-based restrictions?
The court has said it depends. It hasn't applied an inflexible rule that any time you are regulating certain speakers, you are invariably regulating based on content. Instead, the court has said it warrants closer consideration. And here, if you look at the US speakers, TikTok US and the users, none of them are being regulated in a way that suggests it's disagreement with their content. It's all about what our foreign adversary is doing.
It's hard for me to think of situations, maybe they exist, where a classification based on speaker is not viewpoint or based restrictions. I mean, that somebody says Joe can't talk any tomorrow or 2 weeks from now. We don't know what he's going to discuss, but whatever he says is bad because Joe is.
Okay, treason as defined in the United States Constitution is a speaker-based limitation on speech, right? Because you're giving aid and comfort to